May I please, your Lordship? Lordship, I beg to mention item number 14, Lordship. On behalf of Mr. A.M. Boda, Lordship, he is out of station, Lordship. I submitted the adjournment suggestion.
Yes. Okay. What says I represented on the prayer made by Mr. V. A. Chaudhary, counsel for the appellant. Matter stands adjourned today. Just after.
After
We make it 2 weeks.
2 weeks. Highly obliged.
Carlos, I beg to mention item 16.
16, yes.
Kindly take the matter on Friday.
Friday. No, Friday we are not taking up. We'll take it up on Monday.
Lordship.
There are 2 matters already fixed on Monday, on Friday, along with that the other DB matter that is also there.
May I please, your Lordship?
Just a moment. Both says the present on the prayer made by Mr. R. Ali, counsel for the appellant. List on Monday.
25/9.
Yes.
Lordship, I beg to mention item number 57 in the supplementary list, your Lordship.
57? No, I think.
There's no item 57.
Perhaps it's a wrong bench.
57.
There's no 57. Perhaps we are mistaken.
Let me reach 56, then you mention.
The latest item number 1 for admission.
Debt reference matter, your Lordship. Just come up for the first time, but LCR is here.
Yes.
It's admitted.
We'll have to appoint an amicus and then
Lordship. A senior counsel.
uh,
There are 4
Mr.
senior counsels in the panel.
Mr. Kamal,
Yes.
can we request you to be the amicus curiae in the death reference?
All time.
When is the
Yes, Mangal
From the
Praja.
court.
Item 1. Mangal Praja.
Mangal?
Pragha
Perhaps
Praja.
2 persons
two.
were convicted to death. I mean, sentenced to death.
Which place? Session.
Normally,
This-
Normal.
circumstance. It is a circumstance. No, Amara Solias in Amuti. Very dominant. Let's admit proximity. Let's say I see it.
This proceeding arises out of reference made by the learned district judge for confirmation of sentence of death imposed on the appellant, imposed on the 2 accused. For the murder of Santosh Praja, SANTUSS, PRAJ, and Leelavati Praja, LILAWATI, PRAJ. By convicting them under section 302 of the 34 IPC and awarded the sentence of being hanged by neck till they are dead. Full stop. Next paragraph. The court is inclined to appoint Mr. Z. Kamar, Leonard, Senior Counsel, as the amicus curiae in the matter. So the registry shall
Paper book
uh,
prepared.
prepare a paper book and provide copies of the same to Ms. S. Jahan under APP and to Mr. Z. Kamar, to do the instructing counsel for Mr. Z. Kamar, Mr. Whose
My
name
lord,
should I
Biswajit
give?
Talukdar.
Mr. Biswajit Talukdar.
And one more thing, my lord, whether the appellant is.
Yes.
No, we'll have to issue notice.
Yes, yes.
I'll be
There
issuing
will be an
notice.
appeal also.
That one. No, I thought somebody had that. First time.
Last first time.
Hmm?
No, LCR
No,
is-
today first time probably is.
First time, it has come for the first time.
Now I got it.
Next paragraph. The registry shall also issue notice on the two accused persons who are purportedly lodged in the district jail Sibsagar. Perhaps.
Number
I think it was Sibsagar. Not purported, not, to the district jail Sibsagar. But it has happened. In addition to usual process to be sent to the set to accused, the registry shall also send the notice of the appeal along with this reference by email to the Superintendent of District Jail Sibsagar for expeditious service on the two accused persons. Next para, in the notice to be issued to the accused persons, it should be mentioned that in the event they are unable to engage lawyers for themselves, this court would provide them with legal aid counsel for which request can be routed through the Superintendent of District Jail Sibsagar. Next para, the Superintendent of District Jail Sibsagar, on receipt of representation from the accused person shall transmit the same expeditiously to the registry of the court. List on after 4 weeks.
After 4
Give a
weeks.
date.
15/11.
Sorry, just one more
15/11.
thing. Just one more thing.
15/11 is a holiday. नहीं क्या? क्या?
No, it's a restricted holiday.
अच्छा,
Yes.
अच्छा.
16 is open.
I may be celebrating Children's Day on that day. So after that, prior to that, so I may need some holiday. Mr. Kamar,
Yeah, madam.
should I add here that the appellant shall be informed that he also has a right to appeal?
Yes, my lord, that will be better, my lord. Right to choice of a lawyer, my 301, my lord. CRPC.
In the notice above that, in the notice, the accused person shall also be informed
Yeah, my lord, yeah.
that they have a right to file an appeal against the
Yes.
conviction and sentence. For which they may apply for legal aid counsel if they cannot engage the counsel for their own. Just adjust those two lines. Amicus curiae and engagement of lawyer will be one sentence only. List on sentence. Next paragraph, the registry shall reflect the name of Mr. Z. Kamar, done as amicus curiae along with Mr. Biswajit Talukdar as his instructing counsel by listing the matter next.
Right.
Not. Death sentence on the basis of section 34 is little strange.
Huh?
Death sentence on the basis of common intention, 34 is little strange, I think.
In this case, my lord, yes.
Perhaps.
Two
because-
person has been sentenced to
No,
death.
I understand, but you see,
Facts we don't know.
I will not recollect. This incident arose out of the quarrel for a cow.
Oh, for that, that,
for that.
we'll see.
Since I come for the first time, I did not read it thoroughly. Only passing. What do you call? You have the judgment with you?
No, Lordship,
Oh,
nothing
acha.
is served upon
Okay,
us.
Nothing because this is first time
First
today.
time, so.
No, it's okay. I thought that she would.
Yeah,
be
show
having
me.
it, huh? I did not read it thoroughly because it's for the first time. But I found a passing reference to the quarrel arising out of a cow.
Anything is possible. Yes.
So if two people are there assisting each other,
Mm.
then perhaps 34, additional 34 is not so strange.
Killing is always there, my lord. The Supreme Court
Yes.
says with all respect, my lord, numbers of killing is not the question. Question is the brutality in the manner it has been
Brutality,
committed.
right, right. You are
Yes.
That is the
absolutely right.
yardstick. I think.
Yes, yes,
Yes, you are
brutality.
absolutely right.
Diabolical manner,
Mm.
shaking the conscience of the society, my lord. All these things will come. My lord. We'll address, my lord.
Item number 2.
Maybe so we have submitted the deficit food fee, Lordship.
Okay, then we issue notice.
We also filed additional affidavit regarding the cross-examination of the applicant, Lordship, which was not filed earlier. Whether on 15 September we filed it, whether it is on record or not, Lordship, I don't know. Lordship. But matter relates to the that applicant has filed a petition before the Lanet.
So we are issuing a notice
Oh, Lordship.
at this stage. Had Mr. N.S. Laskar, counsel for the appellant, he has submitted that this is a common appeal against the impugned judgment and order dated 27/3/2023, asked by the learned principal judge, Family Court, Silchar, Kachar Silchar, thereby allowing the divorce petition under section 13(1), numerical 1, within bracket IA bracket closed of the Hindu Marriage Act by the respondent, by the. So your case was dismissed and counterclaim allowed.
My case was dismissed due to
Acha, not allowed. Dismissing the petition under so and allowing the counterclaim filed by the respondent. Full stop. Next, the Learned Counsel also submits that is that the appellant has paid court fees for 2 appeals. Next matter. Issue notice returnable in 4 weeks. The appellant shall take steps within 2 days for service of notice on the respondent by registered post with AD as well as by usual process. The Learned Counsel for the appellant is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing.
may fix it, Lordship. Date may be fixed, Lordship.
I'm not fixing a date right now because then puja is coming. We can't adjust if we give a fixed date.
After vacation.
No. You must understand. You see, if I give a fixed date, we'll have to take it up. We don't know. Every matter is being now after 1 or 2 days. Every matter will be adjourned after view after puja. We'll not be able to adjust.
I know.
Item number 3.
May I please, Your Lordship? This is an appeal for whether appellant divorce case was dismissed because the London trial court did not find any ground for divorce. The honorable court's trial court's order is at page 34, Your Lordship.
Okay, dismissed.
Yeah. Yes,
Well, you should notice then. It's J. Paul for the appellant.
so interim prayer is also there because the court directed him to appellant to pay 20,000.
No, that we are not staying without notice. We'll issue notice on the prayer of stage, but maintenance we are not staying without hearing. Oh, my brother is right. You have not read the brief. This was 20,000 was the cost, not
Yes,
maintenance.
Yes, Lordship, that is a
Ah.
fact. Directed him to
No,
pay.
it's okay. 20,000, nothing.
Not till the disposal. Till the disposal.
Let me make it, if you stay it, if you stay the cost, then we'll direct you to pay additional amount for asking your wife to come here. Because in 20,000, if you look back, I don't find any lawyer will accept the brief at lesser than 20,000. No, 20,000 for the wife will not stay. For the appeal against the judgment and decree of dismissal of petition, the decree, judgment decree dated 25/7/2023, thereby dismissing the suit of the appellant under section 13 of the Hindu Marriage Act. With the cost of rupees 20,000. Issue notice returnable in 4 weeks. Notice including notice in the paper for interview returnable in 4 weeks. The appellant shall take steps within 2 days for service of notice on the respondent by usual process as well as by registered post. Same. 4 weeks.
Or
It's come for the first time.
Oh,
May I
yes.
please, Lordship?
It's come for the first time.
Yes, yes.
Yes, sir.
Come for the first time.
Yes, yes.
Okay.
The
This
matter is,
POXO matter.
it's a POXO matter
Okay.
and under section 6(1).
Ah.
And
Should be considered on receipt or LCR.
There was a condonation, there was a delay, perhaps that
Oh,
is.
that's what I
condoned.
asking you, huh?
No, that is condoned.
that's the
Okay, the condom. Okay. Next steps.
Got
complaint. My please, Your Lordship.
Yes.
I'm appearing in legal aid counsel, my lord, stating to the appeal that may be admitted, my lord.
Gotcha. Okay.
And there is
Yes,
a
I
IA, my
think
lord,
that's
I
for
will be
the-
listed along with this. There is a IA, my lord, which has not listed.
Which matter?
Number 5.
And that's the
Councillor,
legal aid counsel.
My lord, IA number 8013.
I have the copy of the IA. It's not perhaps mistakenly listed.
Okay. Available 374 page 1. Notice. Oh, sorry. Admit call for the records. If there is no respondent, no notice.
I think there is.
4 weeks. Notice in the interim application. This is Jan. Okay.
Oblige, my lord.
He is here in the earlier matter, has convicted under 436 for a period of 10 years.
Yes, mischief by fire.
Lordship?
Mischief by fire. House was burned down.
So
By
we
fire.
might go to the single bench. 10 years.
Oh, 10 years will go to single bench. Okay. Okay.
436, oh, mischief by fire. Oh.
Whatever it is, because DB is decided on the strength of the punishment given by.
Yes, yes.
No, no, you are right. You are
More than
absolutely
10 years will come here.
Yes,
It is 10, SI for 10 years only.
right. 10 years would be single bench.
single.
Right. The appellant was convicted.
Highest
And that's for
No,
legal aid counsel.
I.
The the appellant was convicted
I just
for,
checked it.
and sentenced to was convicted under section 436 IPC and sentenced to undergo rigorous imprisonment for 10 years. Full stop. According to the registry shall examine if the matter is required to be registered before the bench of the single judge and list accordingly. 10 years it will be there. Thankful that Jahan and Mr. Kamar had pointed out. Otherwise, it would have been long in passing the orders.
She will be in trouble to have to satisfy two judges. Now she will have to satisfy one
Yeah.
judge.
I think the sentence part is not annexed with the appeal, no? Acha.
I think it's in the front.
In the cost title it is there, but the sentence part, I think sentence hearing was separately, of course, later done. It's not there in the judgment they have annexed. Acha. Has proved the case under 436 and is convicted. Sentence part is not in the judgment.
Okay, okay.
Acha.
6.
We can ask the
Registry to.
registry to get it. Inside there. The government counsel for the Mrs. Jahan AVP has pointed out that she did not find the copy of sentence annexed to the impugned judgment. So the registry shall call for the same and append it to the memo of the
It will come with the LCR. At this stage, yes, the case is deferred for sentence hearing. It's written.
It's okay. Once it is not there, you have pointed out, then the registry get it.
Yeah.
She is a legal aid counsel. She'll be having difficulties otherwise.
Difficult.
Okay.
6.
May I please, Lordship? This is his jail appeal, Lordship.
Okay. 302.
302.
Okay, Mrs. Lee Barbigari. The legal aid counsel for the appellant, Ms. Azan, before the state.
302.
Admit call for the records. List of approvals awaiting the receipt of LCR. IA shall be considered on receipt of LCR.
I is already considered, Lordship. That was
Oh, that is condemnation delay.
condemnation. That was
There is no
condemned.
389 here.
Okay.
Seven.
Seven, today, my lord, we have filed it, my lord. For the first time, it is before your lordship, my lord.
Okay. Rejection of bail.
Bail, appeal for bail, my lord.
Okay. You're accepting notice?
I'm waiting for the response.
You're accepting
Respondent one,
notice?
that is, there are two respondents.
You're accepting
I'm waiting for
notice
respondent one.
for one. Who's number two?
Notice to somebody.
Number two.
No, who is he? He was the SI of police.
Yes,
Yes, sir.
I think
because
so the state can
the state can
accept for it.
Yeah.
You'll file objection by when?
হেৰি দুটা ৰেছপণ্ডেণ্ট কৰিছে
ইনফৰমেণ্টক কৰিছিলো।
He's SI of police. You can accept it for him.
By name, yes, the name is a.
No, no.
Doesn't matter because he's the
informant's name.
informant.
Then PP or something maybe.
By when you will file your objection?
Marat 3 weeks.
3 weeks is a long time.
Not long time, because that has to go.
No, because puja vacations are there.
Yes.
I'm calculating in that manner.
Let's say, let it be 3 weeks.
No, just tell a date because puja vacations are coming. We have puja vacations will come. That's why you just take a date.
Yeah.
There's a calendar in front of you. Give us a date.
Marat, today is.
For bail objection. Today is 20.
We are beginning.
Today is 20.
Today is 20. But there will be holiday in between, Marat.
Take a, you take a opening date. Better to.
No, you take a date. Give a fixed date.
Marat,
Take a fixed date. Just suggest a date.
let me.
আপনি ফাইলে কৰিব এটা ডেট কিমান দিন লাগে?
Let it be 23rd October, Marat.
29th to October is a holiday, my lord.
Holiday, right?
23rd will be a holiday.
My lord, any date before 19, kindly take it. Let it be on 13.
The 13 October.
You file the objection.
yeah.
Let him file the objection on 13. We'll hear the matter on 13 of October.
13th is last day.
Yes. No,
13
actually,
13 is Friday.
No,
No.
16, 17, 18, 19 nowadays it has been made open, my lord.
Oh, acha. Okay. So 13th.
Because it hasn't shifted to November. my
Okay.
lord.
Okay. Mr. Z. Kamal and Senior Counsel, assisted by Mr.
S.J. Chaudhary. S.J. Chaudhary.
S.J. Chaudhary,
Satrapati.
counsel for the appellant, and Mr.
Gita.
D.K. Das, learned Senior Counsel and Standing Counsel for NIA, assisted by
G.D. Chaudhary.
Ms. D.D. Chaudhary,
13.
counsel for respondent number 1, as well as Ms. B. Bhuya, learned Senior Counsel and learned AVP of the state, appearing for respondent number 2. Next one. This appeal is preferred against the impugn order dated
25/7.
25/7/2023 in passed by the learned special judge Nia in Miss within bracket Nia case number 25 or 2023, whereby rejecting the prayer for bail. So, appeal is admitted for hearing. By issuing rule returnable forthwith without requiring the appellant to take first steps. Objection. This appeal shall be filed within 12/10.
Yes,
This is the matter on 13/10/2023.
for here. Much better. And they have issued notice for respondent number 2, my lord.
I have,
But sorry,
I have recorded that.
but they are formal party of the.
No, but you'll have to give him a call.
I'll give.
Or name may be shown. no?
The
PPS also.
registry shall reflect the name of PP Assam for respondent number 2 and within that next. Yes.
My lord, I am praying on behalf of Yashodhari. My lord, appeals to conviction. Under section 4.
Appeal for the first time,
So,
listed for the first time.
yes, ma'am. My lord, this may be admitted, ma'am.
Thoroughly counsel for the appellant and her and Ms. B. Bhuya, learned APP, Senior Counsel and APP for the state. This appeal under section 374 within bracket 2 CRPC is directed against the judgment and order dated so page 1. Appeal is admitted for hearing. Call for the records. The appellant shall take steps within 2 days for service of notice on the respondent number 2 by registered post with AD. In addition, a scanned copy of the memo of appeal along with return of notice be provided to the learned. Be also filed with the registry for onward transmission to the learned APP for service of notice on the respondent number 2. So the jurisdictional to the officer in charge of the Khetri police station.
Yes, 33.
Scan copy দিব লাগিব।
You will give a scanned copy of the memo appeal to
Yeah.
her, as well as a return of notice through the registry. IA is also there. The IA is for suspension of sentence.
Yes, yes.
We'll file our
Issue
objection.
notice. Objection. Here, here is hold this objection, and then you see the this application shall be considered on receipt of NCR.
I'm not.
4 weeks.
Nine.
I- There will be issue notice, huh?
May it please your lordship. This is an appeal preferred against the judgment and order of the learned session judge Lakhimpur, your lordship, convicting the accused under section 302 IPC.
Okay, 302.
Yes, your lordship.
Miss
F. Hussain.
F. Hussain for the appellant. Yes, we are on the APT, senior counsel for the state. Appellant section 374(2). Judgment and order, sentence dated so and so, page 1. If it is admitted for hearing, call for the records. The appellate shall take steps within 2 days for service of notice on respondent number 2 by the usual process as well as by registered post with AD. List after 4 weeks.
Oblige, your lordship.
Oh, Mr. Kamal, that day you made a mention,
Well, it's come, my-
it's come today. Okay.
after some time, probably
Uh,
next cycle.
Because there, the registry has told us, there's a notification of this court. There's a notification of this court requiring that the copy has to be annexed.
But they can't show it, my lord. That is.
Ah, no, now it is
No,
there.
we'll see it, my lord. If the law says that way, then we'll have to go that way. I can paint, my lord.
Ah, Just show the file to him.
Even item,
10 মাতিছে।
10 days. No.
It was high to do.
First time নেবে?
First. My lord, because of two things they have not listed.
No,
for
no,
2
no,
months.
no, we got it.
My lord,
Since I had called it.
no, definitely, my lord. Your lordship, I would also like to see.
You see,
Yes.
we are given these copies, but we don't retain it in.
Yes, sir. Absolutely. Because we are filing it without all those things, because already there is one set.
No, no,
If-
I understand. but
If the law
That's
says
why,
that way, my lord, we'll definitely have to do it.
That's why I called the registry people.
Yes, sure, my lord.
That's why I called the registry people.
No, this is on 2nd March 23, my lord.
No, it's okay, whatever be, but.
No, earlier we never used to do it, so we are not aware of this.
No,
notice, my lord.
I don't blame you, Mr. Kamal.
No.
What I'm saying is that.
My fault, my lord.
What-
Otherwise,
No, not that. You see, because of your mention, I had called it and down, everybody in the section also knows it now.
No, yes, my lord.
So now they can show it to you.
Yeah, sure, my lord.
Huh.
I মানে আমি নব পাইছিলো আগে impugn order to.
Okay,
Now
but-
they are asking it. So we didn't knew about the existence of this notice.
Stay vacation.
Madam, because here actually this notice is holistically saying, my lord, suppose an IA is filed separately, my lord. Here it is written statutory appeal wherein
no, but that's- I get it.
is there.
I get it.
And the second part that I have raised, my lord, for once for all, if it is settled, my lord, it will be forbidden. This is issues resolved, my lord. The second issue, my lord, whether in a criminal appeal any certificate at all is necessary. Page number 23A, we have been inserted, asked to insert it, my lord, if your lordship will see. Put like, show me where it is necessary. Somebody gives it, fine. It's not a civil appeal, ma'am, it's a criminal appeal. I have checked it in the CRPC, it is not there, neither in the High Court rules. Criminal. In a civil appeal, it's mandatory. Yeah, absolutely. We are in a criminal appeal. Because all these issues, if are resolved, my lord, there will be no.
No, no, we'll take care of it. Just give it 2 minutes.
Yes, sure, my lord. Criminal appeal में तो मतलब कोई provision है। CRPC का मतलब नहीं है। मैं network पे high court issues है। पुणे रेस्ट की बता
No, criminal court orders, as I said, what happened?
high court criminal.
No?
नहीं
Hmm. Oh, the criminal cannot support. Nine. Asset. Oh, ikaw na anak.
It's not there.
It's not there, my lord. I have to that even. Because this is an essentiality of a civil appeal, my lord. The lordship can verify it and pass the orders necessarily.
No, we'll do it right now because
Yes,
no point
but,
in deferring it.
yes, ma'am. Because this circular is a high court circular issued by the subsidy.
But even if we fix it tomorrow, we'll have to read it tomorrow.
Yeah, that's
So,
no, not
no
for
point
tomorrow,
deferring
my
it.
lord. I said if your lordship wants to have a
No,
verification.
no,
also.
no, just do it right
But
now.
I'm sure, my lord, and because
No,
we
we
never used
accept-
to give when
we
we used to
accept your
practice
statement.
with
We are
Mr.
not-
Chaudhary.
We are not disputing what you are saying, but just
Yes, ma'am, to make it more
uh,
confirm, my lord.
Hmm.
Pin number है निकला है। Filing number का pin number। बोला ना है। No, 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 no.
this is a requirement only in criminal, civil
Civil,
appeals.
Civil.
$887.
The old book which I was having,
Yes, madam.
I find it more convenient to find out things.
Yes,
In the
madam.
new
New
book,
one is more difficult.
I find myself lost. In the old book, it's all in the hands. Just like a
handy,
back of,
madam.
just like a back of my hand, I
Yeah,
knew
yes.
it.
Used to, madam. আমি ভুলব I'm sure
হয়।
CRPC তো নাই CRPC তো না থাকে
আছে ৰ'ব।
My lord can also have a look, my lord, at section 382 of the CRPC, my lord. How an appeal is to be prepared, my lord. Petition of appeal. It's like a petition setting the grounds for 382 CRPC.
The grounds are required to be.
Yes, that is the mode, my lord, only.
Huh.
So in the petition, we don't give certificate, my lord. I read for your lordship convener. Petition of appeal. Every appeal shall be made in the form of a petition in writing presented by the appellant or his pleader, and every such petition, unless the court to which it is presented otherwise direct, be accompanied by a copy of the judgment or order of appeal. Even the judgment and order is also not necessary as part of this. So nothing regarding any certification or something like that.
No, I'm compelled to read it because of there is a prescription in the criminal business rules of chapter 9.
Yes, ma'am.
There is a reference to requirement of following chapter 4.
Of
So therefore,
general,
I'm
this rule.
Of the general rules.
huh, of the general rules. So therefore, in the general rule, it says requirement of that certificate. I'm just reading it for that.
Sure. Let us be clear, my lord. Because in civil we see it. Some more grounds to certify.
Chapter 4 applies for applicable under this chapter. Chapter 4 is the form. You can say. Exactly. Mr. Z. Kumar, Senior Counsel, assisted by Mr. S.J. Chaudhary, Counsel for the appellant, and Ms. B. Bhuyan, Senior Counsel in the for the state. Next paragraph. The this on mention the mail, this matter has been listed. First of the Learned Senior Counsel for the appellant had submitted that there were some defects.
It was filed on 27th
Defects for which
20th
it was
of
not listed
July.
and therefore mention was made. Full stop. Next paragraph. The registry has put up a note dated 18/9/2023. Point out that as per requirement of notification number 17 dated 2/3/2023, parties are required to mandatorily annex copies of the impugned judgment and order at the time of filing interlocutory applications. Full stop. First of, in view of this said requirement, the learned instructing counsel shall provide a photocopy of the impugned judgment to the criminal appeal section so as to make it a part of the interrogatory application. Next paragraph. The learned senior counsel for the appellant has also pointed out that the registry was insisting that the memo of appeal should also contain the certificate by the learned counsel to be appended to the memo of appeal. In this regard, the learned senior counsel for the appellant has pointed out the provisions of section 382 CRPC as well as the requirement of chapter 9 of the Guwahati High Court rules relating to criminal business. Read with,
Chapter 9, I'm sorry, chapter maybe 11, my lord.
oh, 11, right.
Otherwise, again, that will be complicated.
11, read with chapter 4, Roman 4, Roman 11,
Roman.
for the Guwahati High Court rules, which is required to be complied with as per rule 1 of chapter 11. 11 is Roman 11. First, accordingly, it is submitted that that neither in the criminal procedure code nor in the Guwahati High Court rules, there is a requirement of appending a lawyer's certificate to the member of appeal. First. Next, in this regard, the registry shall put up a note regarding the requirement of regarding the requirement. No, not you have said. There is a requirement. They will.
I'm saying right.
The requirement of appending a certificate to the memo of criminal appeals. On the next fixed. Next paragraph. This appeal under section 374(2) is directed against the impugned judgment and
order
of sentence
24/5/23.
no, they shouldn't do it. Appeal under 374(2), judgment is on page 1. Appeal is admitted for hearing. So call for the records. The appellant shall take steps within 2 days for service of notice on respond number 2 by usual process as well as by registered post with AD. The notice is determined in 4 weeks. In the IA, you see same issue notice. Steps within 2 days. The fearful the suspension of sentence will be considered on receipt of the
আকৌ আহিব
আকৌ আহিছে।
লাগিব আমি থ্ৰু আমাৰ লাগে পক্সত লাগিব
পক্ষতো লাগিব।
থ্ৰু এপিটি যাব
এইটো পক্ষ নহয়।
অ
এইটোতো লাগিব।
কিন্তু এনে পক্সটো
No, there is no requirement of issuance of notice, but once you have.
Yeah, I made it. I'm just
implemented,
verifying it. my lord.
No, no, there's
POXO,
no-
it has become necessary.
POXO has become necessary. No, but in this, since you have added.
Yes, sure.
Return in 4 weeks.
Yes, sure.
And this, I will be considered on receipt of LCR.
Yep.
And you can ask your instructing counsel to give that copy of, photocopy to the section.
Photocopy, we'll give it to the office.
To
Throughout
the section, appeal section.
advocates clerk. I'll do. Much.
Item number 11 for orders.
May I please?
Mr. Kamar, in fact, we may also request you, see, last time I pointed out before you about this notice.
Service notice.
Service of notice. Now, we are again putting up matters in the right perspective for the amendment of rules if required.
Sure, ma'am.
So if in criminal side, if you feel that there is any rule to be required to be incorporated, similarly, just like now you have said about the no necessity of providing this judgment or copy.
Judgment, yes, definitely.
You just give us a note so
Sure.
that
In view of 382 also.
no that
I'll
no,
prepare
whatever
that.
you
I'll
feel
do
like. I am not
Sure.
restraining you.
No, no.
Whatever suggestions you have for the in the criminal side in the
Yes.
rules to be incorporated.
I'll try, ma'am,
Because then we can study it and we can give it to the rule committee
Sure. to look
to
into.
look into it.
Sure,
Because
definitely.
if things are to be simplified, it can be done.
Sure. ma'am.
And
It
if,
will be convenient, otherwise bulky, my lord, all paper. Because already the judgment is there in appeal. Because while probably framing the rules, the notification was issued, my lord. It was regarding a IA in simpliciter. But here, this is a statutory appeal connected IA.
no, I get your
Difference
point.
is that.
I get your point. I'm not saying
Yes, I got it.
wrong, but
But since the notification is saying that we have to give, then we will
Huh.
have to definitely give, my lord. There's
no,
no
but
doubt
still
about
we can revisit the rules. There's no requirement.
Sure, madam.
So if you can point out
Of course, we
something
can
which
point
occurs
it
to
out,
it,
bring it to the notice. We'll do,
we can
madam.
evaluate and then send it
Sure,
to the.
I'll put a
committee.
note, madam. Madam.
If it's things are simplified, it is better.
Yes, absolutely. Much.
Yeah, please. My lord, in this case, notice was issued, my lord. But the last office note dated 30/8/2023 shows that unserved notice or editor of sole respondent has not yet arrived. My lord, kindly allow me to take fresh steps upon the sole respondent. my lord.
Take it by both ways. It will be
Yes.
easier.
Yes, ma'am.
Uh, In view of office note dated 38/2023, Mr. S.R. Babunia,
M. Hussain.
M. Hussain, learned counsel for the applicant, please to allow him to take fresh steps for service of notice on the respondent by registered post with AD as well as by usual process. First of prayer is allowed. Steps shall be taken within 2 days. First of notice is made returnable in 4 weeks. Next paragraph, the learned counsel for the applicant is permitted to collect the postal receipt number from the registry and to submit postal tag report prior to the next date of listing.
Most of it.
Well,
Made Prince's Lordship. So this is a jail appeal Lordship. And the case before your Lordship, II criminal 116 is a
1, 2, 3, 4 days delay. How you
Yes.
explain the delay?
Lordship, kindly peruse the additional affidavit dated 14/6/2013 Lordship. Ground paragraph 3 Lordship.
But this is again that.
Lordship will
Ms.
file our objection.
No, no, no. Here again, the sentence is for term of 10 years.
Yes. Or then
Check
it would
this.
go to
Check
the
this, check this.
single bench.
Check this. You have a copy?
I don't have. Yes, sir.
Just check this.
Live imprisonment.
Judgment of copy. Judgment of copy.
Yes, 10.
Tomorrow judgment.
You will take this file.
The imprisonment for life is there. Lordship.
That is there.
Yes,
I saw 10 years.
under section 4 of the explosion substance act.
Here, he has not
Okay,
annexed
okay.
copy of
Page
the
10 of
judgment.
the impugn order, impugn sentence.
Here, he has not annexed a copy of the
Oh,
judgment.
okay.
No, the memo but is there.
No, no, I did not send out the memo, please.
Memo but is-
You
Page
check
10
up.
of the-
No,
10
no.
years and.
You check up your IA. You check up your IA. You have your IA with you.
Lordship, he was convicted under section 4 of the Explosive Substances Act, and he shall be punished for undergo rigorous imprisonment for life. And
No, no,
liable
no.
to be fined.
You say, let him read the this. You have your IA.
Yes, Lordship.
Read page 1 and 2 in the matter of
The last part, Lordship.
rigorous imprisonment of 2 years
Uh,
for so and so.
Imprisonment
Oh, for life. Okay, okay. Okay, okay. So then it is okay. So what is the delay? Yeah, how you have explained?
Lordship, delay is ground is paragraph number 3 of the additional affidavit dated 14/6/2023 that I had filed, Lordship. Further explain the delay, Lordship. At the time of filing, some documents was not with me, Lordship. Thereafter, I filed the additional affidavit dated 14/6/2023, paragraph 3 of that affidavit. Lordship.
Updated status. Some for SNP. 2023 দেখাইছে 2023 টা।
Section 5 is- Objection 5 is, এই objection ৰ copy টো আছে নেকি?
We have,
Lordship.
this-
We have filed our objection.
But the appellant is not at fault. In the trial court also, he was represented by legal aid counsel,
My lord.
and the legal aid counsel did not report, and therefore this delay. From 2017 till 2022, there appears to be no communication. So this means there is a failure of the DLSA in the 2 ways. That is number 1, to monitor which cases dealt by them has resulted in conviction and non-reporting thereof, number 1. And number 2, the DLSs are supposed to make jail visits and then make an inquiry about the pendency of the whether any appeals have been filed or not. So there are 2 systematic failure.
But we have taken the plea, Your Lordship, the learned counsel. He has failed to annex the written communication as regards the statement made by him, para 5, of the application for condemnation of delay. That there was a lapses on the part of the legal aid
He is a legal aid
counsel.
counsel. In the trial court, he was represented by a legal aid counsel. If that be so, the appellant is not at fault. So we'd have to condone the delay.
Now leave it to Your Lordship. Copy of the additional affidavit is not before me, Your Lordship. I could not go through it.
Charge hearing on this application. Sentence hearing, charge hearing. Sessions. But Mr. Haldar, even here you are, it appears that you look at the memo of appeal and this interlocutory application. Are you satisfied? Look at the memo of appeal as well as the interlocutory application. Are you satisfied that this is in order? You read your, you look at your memo of appeal and the interlocutory application. Do you find it is in order?
This sentence logic. Sentence logic.
No,
Because
you tell us.
against the plea of guilty logic, we can challenge the legality of the sentence only. Lordship.
It's okay, but according to you, is it in order?
Sentence in order. written as or- It's only.
Mr. Hazar,
Lordship will
I
only-
think we'll have to change the legal aid council. We are sorry to say that, but we'll have to change the legal aid council. You see, this is otherwise barred by limitation by 5 years. You said that you took time to get the documents and file it. The judgment itself is not annexed, and you can't find fault with it. So you see, as a legal aid counsel, you see, you are challenging the sentence. Is the sentence hearing, the order of sentence hearing sufficient for us to entertain an appeal? As a legal aid counsel, if you can't find that fault, we'll have to alter it. Otherwise, it will be the appellant who will be
That's why I have
suffering.
annexed the judgment in the 389 petition. also.
Have you done it? That's why we are asking you, did
Yes,
you
Lordship,
find fault?
Lordship, I have annexed it. Lordship.
Where is that?
Is the petition under section 389 CRPC. Lordship. In the
389 CRPC.
yes, Lordship. There is two IA, Lordship. One is for condemnation.
In the memo appeal, you don't annex. Why should I read 389 to find out the judgment? You can't find fault with that. Just 2 minutes back, we are interacting with Mr. Kamar, the requirement of the documents. So you see, as a legal aid counsel, if you don't know what to annex in the writ petition, then your memo appeal, why shouldn't we change you? It appears to be harsh. Language which I am using appears to be harsh. But what can I do? You can't even read and find out the fault in that memo appeal. Now you say that you have annexed it in the 389 application.
Page 12. Lordship. Because in the
Page
same petition,
12.
I took some ground on that judgment. Lordship. Page 12, please.
But the delay we are condoning. It's not his fault. But Mr. B. Haldar, counsel for the applicant, and yes, we have done a senior counsel and done a APP for the state, assisted by Ms.
P. Bora.
P. Bora. Done counsel. Next for that. This. It should be IA 116. This introductory application is filed under Section 5 of the Limitation Act for condoning the delay of 1, 2, 3, 4 days beyond the period of limitation in filing the connected appeal against the impugned judgment and impugned judgment dated 17/7/2017 and sentence dated 18/7/2017 passed by the Learned Sessions Judge Morigaon in Sessions Case number 39 of 2017. Comma, amongst others, comma, imposing a sentence of life, imprisoned for life for committing offense under Section 4 of the Explosive Substance Act 1908 on plea of guilty. Next paragraph. The learned counsel for the applicant has referred to the additional affidavit filed by the filed on behalf of the applicant, and it has been submitted that the applicant was represented by a legal aid counsel appointed by the District Legal Service Authority for conducting the trial before the learned Sessions Judge Morigaon. It has been submitted that the the District Legal Service Authority, Morigaon, did not take any steps to prefer an appeal against the impugned judgment. And only on 15/11/2022, the applicant made an application before the Secretary, District Legal Service Authority through the jailer, District Jail Morigaon, for preferring an appeal before this court. And accordingly, the Secretary DLSA, Morigaon, wrote a letter to the letter dated 19/11/2022 to the Secretary, Guwahati Legal Service. Guwahati High Court Legal Services Committee for filing of an appeal, and accordingly the matter was processed, and the connected appeal was filed before this court on 16/2/2023. By that time, a delay of 1 to 3 4 days had already occurred. Next paragraph. The learned AVP has referred to the objection filed by the state to oppose this application on the ground that appropriate explanation has not been tendered in this interlocutory application for controlling the inordinate delay. Next paragraph. Having considered the explanation tendered by the applicant, the court finds that the applicant cannot be said to be at fault for not preferring this appeal on time, because he was provided legal aid to the DLSA Morigaon before the learned trial court, and that at the instance of the DLSA, Morigaon, the present the connected appeal has been filed. By the applicant through jail, applicant from jail. Next, accordingly, notwithstanding that the delay occurring in filing of the appeal is inordinate, the explanation tendered is accepted to be good and sufficient cause, which had prevented the applicant from filing the connected appeal on time. So accordingly, the delay of 1 to 3 4 days beyond the period of limitation in filing the connected appeal is hereby condoned. Next, registry shall register the connected receipt and list the same for admission hearing. Next para. In the meanwhile, the learned counsel for the learned legal aid counsel shall provide a copy of the influence judgment to be annexed along with the memo of appeal. But Mr. Hazar, we find some sincerity lacking in this interrogative application, which you made me read. You have given the date of judgment as 2022. It should have been 17.
So, Lordship, three person were, 2 person, other 2 co-accused were acquitted by that judgment 2022, Lordship. He was convicted on plea of guilty in the year 2017, and trial was proceed in respect of 2
trial
other
proceeded.
co-accused. Yes, Lordship.
Trial proceeded and
Yes.
the others were
Acquitted, Lordship.
acquitted.
In the year 2022, Lordship. My impugned order is 17/7/2017, Lordship. And by in the year 2022, other
No, but
co-accused were
what is
acquitted,
this language then? You see here you are writing in paragraph 3 of your additional affidavit. After completion of trial, the learned session says Morrigan has delivered its judgment on 27/6/2022, thereby acquitting other 2 co-accused in the case.
Yes, Lordship. I was convicted in the year 2017 on the plea of guilty, Lordship.
Oh. Oh, sorry, we take back our statement. We take back our statement against you. Just a moment. You come to the judgment, shows the relevant paragraph.
Judgment of the other
No,
co-accused.
for you, convicting you.
Is it
Where is that?
page 9 of the memo of appeal, Lordship?
Huh?
Page 9 of the memo of appeal.
No, in the page 9 of the memo.
During hearing of charge, Lordship,
Just a moment.
page 9 annexure 1.
Yes.
Everything is wrong.
Lordship, judgment of conviction is of 2017 as against him. So limitation will start from that day.
No, no, no. We were wrongly reading it.
I
In
know.
fact, out of we, I should say I should be wrong. We are wrongly reading it. What has happened here? I don't know whether it's right or wrong, but Mr. Hazar is not at fault. He's not even required to annex that. That you strike out to annex the copy of judgment in memo of B. That strike out. You see what has happened. We once negative things set in, then we tend to overlook certain things. What has happened here was that in the trial court, before the sessions court, this accused was produced, and the court records that nobody can do anything. He is pleading guilty, and at that stage, the court holds that once he has pleaded guilty, therefore, against him punishment is ordered. Correct. Now, for the rest of the accused, trial was proceeded with, and in 22 they were acquitted. So this man, because of his adamant nature, the court records that this man is of adamant nature, and he has made that statement, and therefore his plea of guilt was taken in the court, and then he was sentenced and put to jail, sentencing to life. But whether that is a right approach, I don't know. You see, a plea of guilt must be by giving him an opportunity of reflecting and then recording it. The recording of the plea of guilt was never done. It is in the open court, just like an accused is standing here in front of us. He said, "You do whatever you like, give me a death sentence." Supposing a accused comes like that, enters the court, okay, you give us death sentence. Don't worry. Can I give him a death sentence just because of that? Look at the Eastern order. Because I please suppose that when there is an order of sentence, I presuppose that when there is an order of sentence, there must be a judgment. In fact, there is no judgment.
Yes, yes, my lord.
So even in a plea of guilt, can it be recorded in this fashion and then sentenced to life?
The accused Sankar Pata repeatedly pleaded his guilty today, despite showing him consequence of guilty pleading. Sankar Pata remained adamant enough and also threatened the court to repeat such type of subversives also. Oh, shit.
We'll not spend the time now, right now,
My lord,
but at least Mr. Halder is not at fault.
my lord.
There's no judgment to be. There's no judgment, and this is a plea of conviction recorded without any documentation of the plea of guilt being recorded. The sessions judge becomes the judge and the executioner. He records the plea of guilt on an oral statement without recording that plea of guilt. In the order sheet, he records the so and so pleads guilty. That's not the way to record the plea of guilt. That plea of guilt ought to have been sent to the judicial magistrate to be recorded. A sessions court in a open court, the demeanor of the witness or the accused can't convict him like that.
Yes, ma'am. Lordship, let the matter come up for admission.
It's okay, but
My lord.
I must.
Lordship is right.
We must take back our what you call our words which we
said to Mr. Hazar, we take it back.
It's okay. Let's,
Because it never offered to us. We just, because you see, there's a judgment elsewhere. So why this judgment is not annexed to the memo of will, that is the query.
Yes.
And we were presupposing that there has to be a judgment and then sentence.
Yes.
There's no judgment to be annexed. Because you see, my brother has rightly pointed out, because we are faced with another situation. 375 CRPC.
Yes.
There shall be no appeal except sentence.
Yes.
Notwithstanding anything in 374, appeal against the sentence will all be against the quantum.
Lordship, there is a division bench judgment of our High Court, Lordship. And,
What is that?
Deal with the same situation, Lordship. In which case, in that case also the appellant was convicted on plea of guilty, Lordship. The High Court, our division bench has set aside the
Remove that sentence to annex this judgment in the memo appeal. Instead, you write in this interpretive appeal, we just add a sentence somewhere. The learned legal aid counsel has submitted that the applicant was convicted and sentenced on based on his plea of guilty before the Lawrence Sessions Court, and that there is no judgment by the Lawrence Sessions Court insofar as the applicant is concerned. And accordingly, he has explained that the memo appeal does not contain a judgment, as judgment is not available. Then you say we are condoned, and then register the connected appeal and send it listed for admission hearing.
Worship. Say explicit bar under section 375 to prefer an appeal when the.
No, appeal may be there, but it will only be a question of sentence.
Yes.
Appeal will be there. That's why they said notwithstanding 374. 374 says appeal can be filed with any sentence of conviction.
Yes.
It says that notwithstanding 374, the insofar as appeal is concerned on plea of guilty can only be against the say quantum of sentence. But this the manner in which the conviction was made, that is something we have to appreciate when the appeal comes. Because the man may be in anger, he may say so many things, but should the court convict him because only of that, without following the procedure?
Yes.
Okay.
So main appeal is coming after registering the case.
After registering it.
Appeal connected petition.
Actually, after Amir Hamza.
In both ways, notices were taken, the steps were sent, but then the report has not come.
Still not come.
And it's awaited. Even I have sent my copies and along with the letter to the police officer to serve it on the victim. Neither I have got any reply, neither the office.
They will have the personal appearance of the IO or this OC, Salvari.
That can be done, but let me find out, then today I'll call that OC.
Let us mention the order, otherwise you see, Mr. Ahmed will be suffering. We can't proceed without the what you call service report. We can't proceed.
Because in one of the case, a few days back, I've come to know that they have not received the copies at all. So I'll have to again talk to the OC. Otherwise, we have sent with the covering letter. So
You see, once you are dispatched, the communication from the office of the public prosecutor doesn't get lost.
Yeah, should not. But one officer said he did not get in another matter.
We also, if I am not, we may be permitted also to take step on usual assessment. Usual process is still not taken.
And I'll speak to the OC.
Usual wise.
Itu puntu thana ase?
Salvari.
Salbari. Salbari. Yeah, I remember. Salbari.
District officer.
But OC Salbari.
How do you send the communication, Ms. Jahan?
We send the copy of the IA along with a covering letter that you have to inform them along with the information that he can.
No, but the mode of transmission is again manual.
Manual, but nowadays, since few days, we have been sending it by email. That is a more better procedure. Earlier, we used to send the entire copy along with a letter. If somebody comes from that police station, we send it by hand. Otherwise, we post it.
Then this man will never receive. Salvari police station, people are not there in your office every time.
Sometimes they come, yes. So let me speak to the OC. Tomorrow, day after, Lordship will take it up. For that information, I can.
You have seen our last order?
I've seen the order as well as the office note, yes.
Because we directed you to send by email.
Email. But I think before that, I had sent the copy of Amir Hamza.
No, but if there's not compliance of this, then we'll have to haul up your office. We have to be equally harsh on you.
Yes, if it is.
You just find out at 2 o'clock, tell us.
Not sure.
Because if not, we'll have to overhaul the system.
Because I remember Salbari, I have sent the copy.
No, that's okay. But if the orders are not compliant, we'll have to overhaul your system. Your office will have to overhaul. You have to pass judicial orders to see that your office functions in accordance with law.
Yes, that has to be there, of course.
Then tell us at 2 o'clock. Tell us the position. How you have sent.
In what way?
That too, I will not have.
It's okay. You ask your.
Only fact is this, my lord. In IA, I am very sorry, my lord. There is some mistake has been done. I may be some mistake has been done.
Okay. You want to withdraw and file afresh, or you want to?
Fresh, I will want to file fresh.
You want to file afresh. Okay. That will permit. Issue the application. Mr. J. Ahmed, counsel for the applicant, has submitted that there are certain typing error in this interlocutory application for suspension of sentence, and accordingly he pays to permit him to withdraw the same and file again. First prayer is allowed. Just before that, you see, Ms. S. Jahan PP is present. Prayer is allowed. Yes. interrogative application stand dispute on withdrawal with liberty to the applicant to file afresh. And in this criminal appeal, we keep it pending at 2 o'clock. Just try to find out,
Noted.
have a word with that.
Hello.
15.
In this case, my lord, Nia has filed an objection, my lord. We have received it just yesterday only, my lord. So it may come up for hearing, my lord.
When do you want?
Worship, if it can be any day after
Both of you agree to a date?
9th of October.
You will be out of station from
I'm
9
out of station.
on 11, my lord.
That is okay with me, Worship.
Huh?
11th of October.
Yes, my lord. Already objection filed, my lord. So hearing will take place on.
But Mr. Z. Kamal, Senior Counsel, assisted by Mr. S.J. Chaudhary, counsel for the applicant, and Mr. R.K.D. Chaudhary, learned DSGI, appearing for the respondent. The objection filed by the respondent is on record. This is the matter for hearing on 11/10/2023, as agreed to by both sides. Yeah, just before that, his appeal is admitted for hearing. And
Yes,
listed for hearing also. Appeal is admitted for hearing without requiring the appellant to take first steps.
That's all.
17.
This I is under 389 for suspension of sentence during pendency of appeal. Such the present petitioners were convicted under NDPS Act under section 22C by learned district judge Bongaigaon. And sentenced for a period of 15 years with fine of 1 lakh.
Just a moment. Yes.
Now, the ground we have put forth in our present petition mainly is that both the petitioners, they are the sole earning members of their family. And the second ground is on law point that the conviction awarded by the learned district judge is perverse and arbitrary, which is based on perfunctory and casual investigation of the investigating authority. The informant, who happens to be ASI, Assistant Sub Inspector of Bongaigaon GRP at that point of time, lodged the FIR alleging that on that particular day he searched coach number B1 of Deoghar Agartala Express at about 1:30 p.m. He got the information, secret information, that on that particular coach B1, contraband materials has been transported by some person. Accordingly, when the Deoghar Agartala Express, the starting point of that particular train was Agartala and the destination is Deoghar, and is happened to be stopped in Bongaigaon Junction for only scheduled time 2 or 3 minutes. Accordingly, at 1:30 p.m., when the Agartala Deoghar Express reached Bongaigaon railway station, the informant, along with his 6 numbers of police personnel, searched coach B1, and as per their allegation, they apprehended the present 2 petitioners along with another petitioners, another convicted one, and found contraband materials. Lordship, our main legal contention is that the position of contraband materials from the present 2 petitioners has not been proved beyond all reasonable doubt, as envisaged under section 34 and section 35 and section 54 of NDPS Act. Because for conviction under NDPS Act, the prosecution first must prove the possession of contraband materials from the accused beyond all reasonable doubt. Now the question, how in the present case the prosecution failed to prove the possession of contraband materials beyond all reasonable doubt. Lordship, when the informant searched the coach B1, along with him there were 6 police personnel, and according to him, he found that contraband materials from the present 2 petitioners along with another co-accused, which appeal has been preferred by some other lawyers. The informant, when searched the particular coach, along with him there were 6 personnel, but during trial none of that 6 personnel were examined or their evidence has been adduced, which created doubt under section 114G of Evidence Act. For a moment, what section 114G says, for a moment. 100 section Evidence Act 114G.
Yes.
114G, the leading line is, court may presume existence of certain facts. 114G, that is illustration part. The court may presume, G, that evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. So there is a doubt. The informant, along with him, at that point of time of search, there were 6 personnel. Why they could not produce their evidence during trial? None of that 6 police personnel were examined or given their evidence. Now our second point is that the seizure list, in the seizure list, there were 3 independent witnesses.
No, you see, The principle in examining the evidence
Yes, Lordship.
for suspension of sentence is very limited. We can't reappreciate the evidence and to say
Yes,
that the
sir.
conviction was not possible. So therefore, we have our limitations in hearing the
Yes, Lordship.
application of a suspension of sentence.
Yes, Lordship.
We can't reappreciate the evidence and then find out fault and then say that the conviction itself was not permissible.
Yes, Lordship, very much true. But there, Lordship, there is a latest apex court judgment under on 389 section of CRPC. Latest apex court judgment of May 2023. What
Sure.
that judgment says? Almost 2-3 paragraphs are important, but I will read only the most important paragraphs.
Yes.
Paragraph 25. May I read, Lordship?
Yes.
In Rajesh Ranjan Yadav alias Pappu Yadav versus CBI reported in 2007, 1 SCC 70, it has been held under paras 8, 9 and 10 respectively, which are as follows. Learned counsel for the appellant then relied on the decision of the court in Kashmira Singh versus State of Punjab, 1977, 4 SCC 291. In para 2 of the state decision, it was observed as under. It would indeed be a travesty of justice to keep a person in jail for a period of 5 or 6 years for an offense which is ultimately found not to have been committed by him. Can the court ever compensate him for his incarceration, which is found to be unjustified? Would it be just at all for the court to tell a person, we have admitted your appeal because we think you have a prima facie case, but unfortunately, we have no time to hear your appeal for quite a few years, and therefore, until we hear your appeal, you must remain in jail, even though you may be innocent? What confidence would such an administration of justice inspire in the mind of the public? It may quite conceivably happen, and it has in fact happened in a few cases in this court, that a person may serve out his full term of imprisonment before his appeal is taken up for hearing. Would a judge not be overwhelmed with a feeling of contrition while acquitting such a person after hearing the appeal? Would it not be an affront to his sense of justice? Of what avail would the acquittal be to such a person who has already served out his term of imprisonment, or at any rate a major part of it? It is therefore absolutely essential that the practice which this court has been following in the past must be reconsidered. And so long as this court is not in a position to hear the appeal of an accused within a reasonable period of time, the court should ordinarily, unless there are cogent grounds for acting otherwise, release the accused on bail in cases where special leave has been granted to the accused to appeal against his conviction and sentence. Now, Lordship, the second important paragraph is 33.
What is the citation? What is the
Citation is, Lordship, 2023 6 SCC 123. That is Om Prakash Sani versus Jai Shankar and
Chaudhary.
33, Lordship. 33 paragraph is, to my humble understanding, is important. 33. Bearing in mind the aforesaid principle of law, the endeavor on the part of the court, therefore, should be to see as to whether the case presented by the prosecution and accepted by the trial court can be said to be a case in which ultimately the convict stands for fair chances of acquittal. If the answer to the above said question is to be in affirmative, as a necessary corollary, we shall have to say that if ultimately the convict appears to be entitled to have an acquittal at the hands of this court, he should not be kept behind the bars for a pretty long time till the conclusion of the appeal, which ultimately take a very long for decision and disposal. However, while undertaking the exercise to ascertain whether the convict has fair chances of acquittal, What is to be looked into is something palpable. To put in other words, something which is very apparent or gross on the face of the record, on the basis of which the court can arrive at a prima facie satisfaction that the conviction may not be sustainable. The appellate court should not reappreciate the evidence at the stage of section 389 of the CRPC and try to pick up few lacunas or loopholes here or there in the case of the prosecution. Such would not be a correct approach. Now, Lordship, in our case, I am not citing the lacunas here and there. There is a prima facie.
Just wait, we'll take a break and come back. Just.
To my humble understanding, the gist of that particular judgment is that suspension under section 389 can be allowed by an appellate court when there is a prima facie case or acquittal of the convict. It is the gist of that particular case. And that particular apex court judgment was the background of that judgment was conviction under 302. So, in my case, Lordship, whether there is a prima facie case of chances of acquittal of the present petitioners, I would like to submit only 2-3 points on legal grounds.
Yes.
When the Lordship particular on that particular day, when the contraband materials was seized as alleged by the informant, the seizure witness which they have shown in their evidence in chief as well as in cross, they have categorically stated that we have not seen from where and how the materials has been seized. Number one, section 51 of NDPS Act says that the procedure of warrant, arrest, search and seizure would be followed as per CRPC. Now, section 100 of CRPC, there is a procedure has been laid down, and subsection 5 of 100 CRPC, it says that during search and seizure, the seizure witness must be physically present. But in this case, Lordship will see in their evidence, in their evidence, they have categorically stated in their evidence in chief as well as in cross, that is PW 1, 2, 3, who were independent seizure witness, that they were not physically present at the time of search and seizure. During cross, both three seizure witness stated that we have not seen from how, where that contraband materials has been recovered from the accused. This is our prima facie case in the appeal. Now, as per section 35 of NDPS Act, which says that for conviction under NDPS Act for any contravention of provision, for any contradiction, so for any punishment under NDPS Act, the possession or recovery of contraband materials must be proved beyond all reasonable doubt. Beyond all reasonable doubt, which is not in this case. Number two, the particular informant who happens to be the ASI, Assistant Sub Inspector of GRP, Bongaigaon, at that point of time, in his cross-examination, he stated that I have not prepared the seizure list. Whereas the IO PW6, he stated that it is available in the record. He stated that I have not physically seized that contraband materials. There is a breaking of chain, prima facie breaking of chain.
Where is that? PW6.
PW6 IO. IO. Lordship, my one little ground is that there is no previous conviction of the present petitioners. Any criminal antecedent, there is nothing. PW6 IO part. Yes. Yes, Lordship. IO part, last part, from bottom, third paragraph. I did not physically seize the suspected cannabis from the.
Which page?
Lordship, it is in our. Just a minute, Lordship. In our appeal memo, at page. It was also stated in the Intune judgment, whole statement of the PW6 at page Lordship, yes, Lordship, at page 17, oh sorry, 32, impugn judgment. Impugn judgment, page 32, 1, 2, 3, 4. From bottom, fifth line. He did not physically seize the suspected cannabis from the possession of the accused person. It is the version of the IO. Now, Lordship, what in the seizure list the IO has stated? Let us see for a moment. Seizure list. Seizure list I have not annexed with the appeal memo. May I read, Lordship?
Yes.
Seizure list. I, SI Madan Chandra Kolita, Bongaigaon, GRPS do hereby seize the following articles from the possession of such and such accused person. There is the seizure witnesses, which I have just earlier mentioned, PW 1, 2, 3. And the note below, Lordship. Kindly in the seizure list, note below. That part is very important.
Which page?
Lordship, in the seizure list, Lordship. It is available in the LCR. Note below. May I read, Lordship?
Which seizure list? There are two seizure lists.
There is two seizure list.
Which one?
In our case, that is, there are two accused person name mentioned. Thumb impression of two accused person is there. Bipin Kumar and Veera Mahato.
Yes.
Yes, that is. I am representing these two accused.
Huh.
Note below. May I read, Lordship? It is to be mentioned that the train bearing number and name 15626 Deoghar Weekly Express train arrived at New Bongaigaon Junction on 13 February 2022, arrived at 1:38 p.m. and departed from the New Bongaigaon Junction at 1:42 p.m. Hence, unable to seize the recovered items from running train due to shortage of time, that is approximately 5 minutes. Now, this statement of IO in such a serious case, non-est in the eye of law in view of section 49 of NDPS Act, because 49 of NDPS Act empowers to stop and search a conveyance, empowers the particular authorities to stop and search a conveyance when they get any information that any contraband materials or anything is happened against NDPS Act. Information was received at 10:30 a.m. morning by the informant, who was ASI of GRP New Bongaigaon. 10:30 morning, information received, train reached the station at 1:30. There is about 3.5 hours. Why they could not exercise the power under section 49 to stop that particular train for a few more moments in consultation with the railway authorities, so that the seizure can be made following all due process of law. It is a not valid ground that only 5 minutes the train stopped and I could not follow the procedure of seizure as under law. It is prima facie case. Now, Lordship, in the particular seizure list, one thing is more. In the particular seizure list, it is shown description of seizure. May I read, Lordship? In the description part, one purple color plastic sack containing suspected to be ganja, total weight 10.800 kgs. That means 10.800 kgs, whether it is a commercial quantity or intermediate quantity. Because as per schedule of NDPS Act, commercial quantity is 20 kg and above. It is 10.800 grams from that particular two person. it was prima facie material in the seizure list. Now, Lordship, another very important point is that the IO in his FIR, he stated that he searched the coach B1, whereas under 313 examination of that particular 2 person, they stated that we were in coach S2. The IO stated that I searched coach B1 and found that 3 person. And 313 examination of the particular these 2 petitioners, they stated that we were in coach, sorry, it is a sleeper coach S2, and their ticket number, coach number were also mentioned by that informant in his examination in chief. True contradiction, breaking of chain. For a moment, Lordship, kindly see the evidence part of
Yes.
Lordship. Now the evidence part of IO is PW4. Evidence part of IO is PW4. In his cross, Lordship, in his cross part at page 2, in his cross part 1, 2, 3, paragraph 4 from top. One copy of train ticket in the name of Suraj Kumar Roy is seen in coach number B1, seat number 19, upper berth. It is a AC coach. Another copy of train ticket seems to be in the name of Bipin Kumar and Bira Mahato, coach number S2, seat number B and seat number 8 and 6, which was corroborated by the present 2 petitioners in their 313 examination, that we were in coach S2, mentioning their particular seat number, but IO has stated in the FIR that they were found in coach B1, which is a AC coach. In AC coach, other passengers were not allowed by the police authority. It is a common transaction during travel. Within 5 minutes, he searched the train with his 6 personnel. None of that 6 personnel were examined, given their evidence. 3 seizure witness picked up from the platform. They are projected as seizure witness. In their evidence examination in chief, they stated that we are not physically present during search and seizure. In cross-examination, both three seizure witness PW 1, 2, 3 stated that we have not seen from how and where the contraband materials recovered. It is a prima facie lordship, prima facie materials in the case. And there are so many lacunas in their investigation. I may show in the full-fledged hearing at the appeal stage. IO has shown that 10 kg 800 gram contraband materials seized from this present two petitioners, whether it is a commercial or intermediate quantity. Certainly it is an intermediate quantity and convicted for commercial quantity. It is quantity part is a part at the stage of appeal, I will argue. But prima facie the seizure witness, they himself said that we are not physically present, which is a mandatory guidance of 110 of CRPC. Subsection 5, that seizure witness must be physically present. And in their evidence and cross, they have unequivocally stated that we are not present. From how, where they have seized that contraband materials, we do not know. Merely projecting, Lordship, it is my, I may be wrong, subject to correction. Mere projecting some materials. This may be a case of that like that. Bringing some materials, contraband materials, which is available at any moment with the authorities, police authorities. They may bring some materials projected with them, trial held, they are sent to jail. Since
I don't know, unless you take a point, we can't take cognizance of that.
Lordship,
You see, we can't, the court cannot make a passing remark that it is available with the police.
yes, Lordship, yes,
This is something you'll have to show.
yes, Lordship, yes,
Because if you take that plea, it will be your burden to prove.
yes, Lordship. We have already stated in our 313 examination that we have not possessed that.
No, that is okay. But
Yes.
to make a statement that the police always carries.
No, Lordship. It was my out of record, subject to correction, Lordship. It was my. I withdraw that particular statement. I withdraw. I just assume such a facts. I just assume, Lordship. I am very sorry, Lordship.
It's okay. It's okay.
And Lordship, and now my last point is that they were arrested in the month of February 2022. Till that they are behind the bar. Already more than 1/10 part of the imprisonment they have served. 1/10 part. 15 years has been given. 15 years conviction has been given.
That is the problem. Satyendra Kumar until says 5 years or half of the sentence.
Yes, Lordship. Yes. Lordship, in view of the present apex court judgment we have, which I have cited, considering that judgment, Lordship, because there are no any criminal antecedents of that particular 2%. One person is just coming of age 22 or 23 years. He was working in Agartala in Itavatas with that co-accused. They were coming from Agartala to Devgarh. They were resident of Bihar. They were laborer. They were picked up in the Bongaigaon station, sent to jail. In this case, they have already all minor, particularly the petitioner number 1, he has only a minor daughter of 1.5 years. Petitioner number 2 have 4 children, all are minor, no criminal antecedents. Prima facie case is that the case may succeed at the stage of appeal. So, keeping in view the facts and circumstances, the Lordship, conviction may be suspended.
Okay. Yes.
Imposing any conditions.
In fact, in the judgment that he has himself placed, their Honorable Supreme Court has clearly laid down the law and had said that the High Court need not go into go deep into the matter in 389 application. In fact, in that decision, the High Court had allowed the bail application and Supreme Court has rejected it and saying this. And Supreme Court has also said that to see whether a case will result in acquittal, in 389 application, High Court will only see what is palpably wrong. It will not go deep. What is on the face of it is wrong. Here, what had happened? FIR delay in lodging of FIR and certain things were taken into account and bail was granted. And it was heavily brought down. It was, Supreme Court has heavily come down. So in fact, here is a case where, and in fact, in that case, it is also said that the appellate court should not reappreciate the evidence in 389, trying to take out some loopholes and send it on bail. Here, the grounds that he has taken, that the quantity is less, but here, in fact, 3 persons were arrested together and the total amount was 21 kg. So it is above the commercial quantity. And the independent witnesses 1, 2, and 3, they have, in fact, they were there in the railway station. They had seen, of course, they did not go into the court. They said that it was recovered, and we had seen him, the suspected drugs were recovered. And the section 49 that he has shown, 49 perhaps, of course, I have to do some research there. 49 is perhaps where a car comes with some suspected drugs and it tries to flee away. Then in that case, one has to stop it by every means, the police will stop it.
No, there is a point because of, you see, the NDPS Act, there is no exception carved out for aircraft or a rail. So
yes.
they are both conveyance.
Can we? But I'll have to see, because train, there are so many passengers, let the train go, things were brought down. And then it was seized in the platform. Because 5 minutes, 4 minutes, the train stopped.
Then also there some safeguards has to be taken. Because the harsher the punishment, the harsher the
stricter the
procedures.
Yes, of course. But here is the case where the train was...
You see, had to be documented, where now nobody can say that they were unable to take photographs because everybody has mobile. The photographs could be taken. The position, because you see, there has to be a constructive and conscious position.
Yes, those has to be seen, and those Lordship will see during the time of hearing. Conscious possession, which coach they were in, what tickets they were. But then there are independent witnesses who said that they entered into the coach and then they brought out the suspected drugs. And rather, in fact, the other procedures, Lordship will see here, of course, NDPS Act, there are so many violations and so people go out. Here, they got the secret information, they entered it into a GD entry. Thereafter, they got the authorization, they have informed to the superior officers, they got the authorization, they went and searched. In the meantime, the OC reached and they had seized, they brought it to the police station, they kept it in the Malkhana, they made the inventories. All these procedures, in fact, 52A was also followed. It is in the statement of the IO as well as the person who had seized. So those procedures were in fact followed. Only the 3 points that he has raised, 49, I'll have to see. This is not where Lordship will go into at this stage. And the other, this is for commercial quantity, independent witnesses were there. So in my humble submission, relying on this particular case again, it's not a case for bail. Let us do the hearing in a short period of time.
PW, the iOS PW6.
iOS PW6.
iOS PW6, and he visited the place of occurrence, he examined the witnesses, made a prayer before the court for sampling. Lordship has found out something.
Oh, a question to you.
Lordship.
You see, these three witnesses, PW 1, 2, and 3, were probably the seizure witnesses. They all say that they had tea stall and they were busy in their business and they did not go to the
Huh.
train to see the seizure. Therefore, this seizure per se becomes questionable. Because the seizure is made, the goods are brought out. Now, parallelly, he's also saying that the goods were in fact removed from the train and brought out and then seized. Therefore, first set of evidence saying that they were not inside the train, that itself creates a doubt because of the fact that where was the seizure done? Was it inside the train or from the train it was removed, brought out in the railway platform and seizure was made there? So where is the status of seizure? That is number one. And number two, when the IO says in his cross-examination that he did not physically seize cannabis from the possession of the accused persons, then why we should not grant bail to the
Lordship, in fact, the independent witness will not, the concluding witness here, will not conclude the matter. Lordship will go to the evidence of PW4, who was there when the articles were seized, because IO came later. Lordship will see PW4. Lordship, PW4 statement will not be. No, no,
You want this?
And Lordship, yes, he has it. Second is seven. So PW4, he is the one who was in charge of the GRP. Lordship will see. After receiving the information, Lordship will skip that part. Conducted, I informed the matter to so and so, I conducted search, which authorization letter was sent. I, along with my staff, boarded the train and conducted search in coach number B1. While search, I found 3 persons. 2 of them were holding purple color plastic sack and 1 person was holding a blue color bag, and they were trying to go to another coach, avoiding search. This may be a case. He is saying that the coaches were different. So perhaps they had come and gone. So that can be a fact. We restrained the 3 persons and searched them. On being asked, they told their names to be Suraj Kumar Roy, who was holding the blue color, and the other 2 are these appellants. On search, we found the suspected ganja in the purple color bag, and accordingly, 3 persons were taken out of the train. I informed the matter to OC. He said he'll come and seize the articles. We took the 3 persons along with the recovered articles to plate form number 1 in front of GRPS office. OC Bongaigaon reached there, seized and measured the articles in presence of witnesses. I was also present there at that time. So he was the one who has proved the seizure. The total weight of the suspected ganja in purple is 10 kg, and the total weight is of the other bag is 10 kg, 210 grams, excluding the trolley bag, which was rep. So OC Bongaigaon interrogated them to Bongaigaon GRPS on that day. Lordship will go to his cross-examination. Lordship.
Lordship, will continue.
Lordship.
Yes.
That service matter, they have served it and sent the service note to the session judge. And that service matter to the in the earlier matter, the police were supposed to serve the notice upon the, and they have served it and sent the service notice to service note to the session judge. So I brought it, but they have served it on a female member again. So again, they have to, wife of the respondent.
Yes.
And Lordship has already, I have shown your Lordship PW4's statement. And along with that, the independent witnesses, they have not gone inside the train, but they had seen the seizure from a distance, they said. Seizure made by the police officers at that point. They were at a little distance. But coupled with the evidence of PW4 and the PW and the IO, the basic requirements of seizing and all other requirements under the NDPS Act are fulfilled. The rest we will see, 49 and all, we will see at the time of hearing.
So I have a simple reply to this point of 49. I just read one line of PW4, who is the informant. In his cross-examination, sorry, Lordship, in his in chief. Yes. Sorry, Lordship, in his cross-examination, last part, he stated that PW4 informant.
Cross-examination. Cross-examination.
Yes, Lordship. Last part from the bottom, fifth line.
Now he's referring to the judgment.
Huh?
He's referring to the judgment. He's referring to the judgment.
The judgment. But just say that.
In our Lordship appeal memo, judgment is at page 28. That
okay,
just
read that part.
Yes. He stated that in cross, seizure list was prepared by Modern Kolita, that is PW6, at 4:30 p.m. After measurement, he did not do any measurement. That means the PW4 did not do any measurement. Now the point is, Lordship, PW4 being the informant and ASI of that particular railway station, he has the power to search, seize under section 42 of NDPS Act. Train reached at 1:30 p.m., left the station at about 5 minutes later. He could have exercised that power of search seizure following all procedure because section 42 clearly stated that particular officer, ASI, can seize, and section 49 gives a, Lordship, what I can say, it is more stringent power, because under section 49, a police officer can even fire up a conveyance. He has given that power. He can fire. It is stated in 49. So when such large powers has been given, he has not exercised it. There is a doubt why he has failed to exercise that particular power, why he has waited for Madan Kolita, that is the IO, till 4:30 p.m. Whereas he has, as his statement, he has seized that contraband materials at about 1:30 p.m. inside the coach. Why he waited for large 3 hours, as he has given power under 42, section 42 of NDPS Act. He has very much power. He failed to exercise that power. There is a breaking of chain. And Lordship, under my last humble submission is that it is a clear case that prima facie case is that the basic principle of conviction under NDPS Act is to prove possession beyond all reasonable doubt, not mere a preponderance of probability. The benefit of preponderance of probability can be utilized by the accused, not by the prosecution. First of all, prosecution has to prove the possession contraband material, that is cannabis, beyond all reasonable doubt. My humble submission is that when train is stopped only for 5 minutes, why it could not be stopped for more than 1 hour? More than 1 hour, so that the seizure and search could be done as per law. This is my humble submission, Lordship. So my petition may be allowed.
Okay, we'll consider
With
it
any
after this.
conditions.
No, that is why I said 49 is we can see a situation where somebody tries to flee along with the vehicle. Now there will be so many patients. It's a public train, and stopping the train, rather they brought them down. Of course, I'll have to get some judgments on that.
You can search for the judgment after the order is over.
Not if yes, and during the hearing also.
I have cited that particular judgment, and there is so many other judgment, that is Noor case in the NDPS Act, and one Lordship, last thing I have forgot, the trial judge, there is a, it is, maybe I am wrong. It is a half-done judgment. Maybe I am wrong because I have little knowledge about the full, because I have so many, I have not crossed that so many length of practice.
But then unless you are very sure, you can't argue before a division laying some legal proposition.
Yes, Lordship. Yes. Lordship, in the
you must be convinced first.
Yes.
That what you are saying is right.
Yes.
Then you can make your submission. But if you are yourself confused whether it is your submission is right or wrong.
Oh yes. On that point, Lordship, in the judgment, the learned trial judge put 2 points for decision. Only point number 1 was decided. Nothing has been discussed about point number 2 in the entire.
What is the second point of determination?
Yes,
what is the second point of determination?
Yes, Lord. Yes, it is, Lordship. Second, regarding second point of is whether the accused persons on 13/2/2022 at 10 a.m. were a party to a criminal conspiracy. Section 34.
Section 29 of the NDPS.
Criminal conspiracy to commit the offense of transportation of ganja, thereby committed offense punishable under section 29. It was not discussed in the entire judgment. And even, Lordship, last point. Now, my memory is coming little by little. Even, Lordship, the learned judge has even not discussed our own High Court judgment, which was cited on behalf of the accused. That is Vishwanath Pratap Singh. Yes, Lordship. That is Vishwanath Pratap Singh and another versus State of Assam, 2021 5 GLT. It was cited, but it is very much
Page,
applicable.
page. complete
Page
that.
710. He refused to discuss that judgment.
These are subject matter of the appeal.
It is a large part of appeal hearing.
Gotcha. Obliged.
In the Vishwanath Pratap Singh case, the Nuraga case has been extensively discussed. Nuraga case laid down some principles under NDPS Act regarding search, seizure, etc. In Vishwanath Pratap Singh, para 21 is relevant.
Okay.
Yes. Obliged.
Oh, yes, the service notice.
Yes, you want to say something?
Lordship, this is that service note I have.
Lordship.
Yes, it is there, Lordship. The police have served it on the wife of the informant. Hamza Ali's wife. Hamza Ali Nahan. Okay. Yes. His
Mazam Ali.
Majam Ali's wife, Hawa Khatun. Now I've told them to serve it again. Hawa Khatun.
Sauya.
This was served on 19/9.
Okay.
I've told them to serve it on a male member if they don't find Majam Ali.
I think it would be better if we just quote that provision.
Yes, yes,
Otherwise
they don't
this-
know, otherwise, they don't know.
No, they don't want to know.
And they don't want to know, yes, there's a difference. Section 62.
It opens in others.
Sixty-four. Service when person summoned cannot be found. Section 64.
No, this High Court rules also have
Acha,
that.
yes. High Court rules also have it. That's good. Yes or no?
Which provision you said?
64 of CRPC.
64. Mr. J. Ahmed, counsel for the appellant, and Ms. S. Jahanlal, AVP for the state. Next para. The learned AVP has produced a scanned copy of the service report of process issued on respondent number 2. By which the officer in charge of Salwari police station had served the notice issued to respondent number 2 to his wife.
Hawa Khatun.
Sanya.
Hawa. Hawa Khatun. HAWA.
This is H.
No, this is Ho in Assamese.
No, in English, he is writing, namely
Oh.
SAUYA, that this copy which he was
Sauva.
giving us.
Acha, acha. At the top, in the top, it's written in
Hawa.
Assamese, Hawa.
Oh, okay.
It's
to-
written SSH.
to Hawa. Hawa Khatun, wife of Mazam MAZAM Ali. Stop. The next paragraph, they said service would not constitute proper service of notice to the respondent number 2. Full stop. In this regard, the court is inclined to refer to reproduce the provision of section 64 CRPC as well as Rule 6 of Chapter 11,
Chapter
numerical 11,
Achha. Chapter
of the Guwahati High Court Criminal Rules and Orders. This is at page 148. Next paragraph. The learned this notice will be prepared by the registry.
Yes.
Huh?
And the rule is registry will give it to me, I'll send it.
The registry shall issue a fresh notice to the respondent number 2, which should be prepared and provided and furnished to the learned APP for onward service to the respondent number 2. So the officer in charge of Salwari police station. Next paragraph. The officer in charge of Salwari police station shall take note of the provisions of law extracted herein before and shall ensure that the process is served to the respondent number 2, as far as it is practicable, and in the event the respondent number 2 is not found, service shall be effected on an adult male member of his family in the manner indicated in the provisions of section 64 CRPC as well as rules 2 to 5 of of chapter 11, part A of the Guwahati High Court Rules and Orders, Criminal Court Rules and Orders. Chapter 11, part A. Next part. The learned APP shall send the notice to the officer in charge of the Salwari police station through email, and the said police station will make a printout and serve it to the respondent number 2. Next paragraph. In the notice to be issued by the registry, it shall be mentioned that in the event the respondent number 2 is unable to engage his counsel, he would be provided legal aid for which he should apply to the Guwahati High Court Legal Aid Committee. Next paragraph. This one, give a fixed date for
1310.
this one should be, so what I could do, the officer in charge of Salwari police station shall ensure that the service report is returned to the court through the officer of the public prosecutor Assam, Guwahati High Court, prior to the next date of listing. So you wanted to take steps yourself.
No, they have withdrawn the IA. They will file it afresh.
I'll file I.
So in this appeal also they have to.
Appeal,
file
they
it.
have not said. Acha. Appeal to be.
No, appeal is said he'll be taking the steps. For that we have already passed orders in the appeal. Okay. In addition, the counsel for the appellant is also permitted to take steps for service of notice and respond, but through usual process to be routed through the jurisdiction of the magistrate. Full stop. The authority would be serving the process shall ensure that the process is returned prior to the next date of listing.
I think that provision is under challenge before the Honorable Apex Court.
Which one?
It's section 65, adult male member. But the judgment is not out.
Okay, is it? We don't know.
Right.
We don't know.
I'll place that. In item number 18, the paper book is ready, but they have filed a IA very recently, it seems, yes. I'll file my objection to that IA because otherwise paper book is ready.
Miss
Jason Poe.
Jason Folk, counsel for the applicant, and Miss S. Jahan, APP for the state, and Mr.
On behalf of my senior,
No, what is your name?
Khinul Islam. Khinul Islam.
A.
A.
Islam.
Islam. Counsel for the informant. Next one. You should notice on this interrogatory application for suspension of sentence under section 389 CRPC. Objection, if any, by the informant and the state shall be filed 2 days prior to the next date of listing. List after 4 weeks.
Not.
The LCR has come.
Yes, the paper book is ready.
Okay.
19.
Paper book is ready here also.
Lordship, my lord, this matter may kindly be taken on Friday. I have another, I think,
No,
20.
Friday we are not taking up because Friday there are some meetings scheduled and I'll be traveling.
Next week, and any day.
I filed my objection, it's there.
Objection is already there.
Okay. Next week, when do you want?
Kitya lagi. When do you want?
Fix it on 26th then?
Let it be on 21, my lord.
No, 21 will not take up.
Oh.
Because I told you I have difficulties.
Let it
There are
be
meetings and I'm scheduled
maybe
to
on-
travel.
on 22, it may be.
22 again. Lordship is not sitting. Friday.
No, Friday, next week you take any day.
26.
Then 26.
26th or 27th.
26 is a hearing day, my lord. It will be better. 26.
Okay. Your objection is not there. Ready to file it?
I filed it long back.
Yes. They have filed
No,
a-
notice has not been issued. in this IA.
It was issued and I had taken time.
I don't know. You see whether the order has been passed in the main case.
This IA has come for the first time.
This
Earlier IA was rejected, thereafter second IA.
Oh,
was-
acha, acha.
Okay.
Then I don't know. The earlier I filed my objection. Oh, that was rejected.
This comes the first time.
Okay. I thought it was the last one.
For Mr. Alvi Mahmood, then counsel for the applicant, and Mrs. Jahan and the APP for the state. Anybody is appearing for respondent to?
Today is not, but
Oh,
on earlier occasion,
names are not reflected.
names are not reflected. I think when earlier, as the earlier IA was rejected, so that may not be necessary.
No, this can't be taken up unless notice is served and respond with this POXO matter.
Then Lordship may kindly allow us to take the service.
Justice service we may not permit. Because if it's a POXO, again to have the victim interact with the informant may not be appropriate.
It will be served through guardian.
Huh.
Through her guardian.
But the amount of interaction with the victim, that may not be advisable. You just write in the appeal first. At this time, Mahmood counsel for the appellant and Mrs. Jahan counsel for the APP for the state. Next paragraph. It is observed from the record that it appears from the record that it appears from the office note dated 31/2023 that instead of taking steps for service of notice in the on respondent number 2 in the in connection with this appeal, notice was issued on the respondent number 2 in the connected interlocutory application. Moreover, it appears from the order dated 15/2023 that service report in respect of respondent 2 is not available.
Whether it may can be taken by learned trained.
Be that as it may, the appellant shall take steps within 2 days for service of notice on respondent 2 by providing a scanned copy of the memo of appeal with enclosures thereto to the registry together with a written up notice. Same over the corrections. And the notice it will be reflected that the respondent 2 would be entitled to legal aid that at that time. Notice is made determined on give a fixed date and so based on so and so. In the I also will write same thing. Issue notice on this interlocutory application returnable on so and so. The learned counsel for the applicant shall provide a scanned copy of the of this interlocutory application to the registry along with a return of notice, which will be forwarded to the learned APP for onward transmission to the respondent number 2 through so and so police station. Which police station?
Kokrajhar. Bagri Bari.
Bagri Bari police station.
Bagri Bari police station.
Kokrajhar district.
Bagri Bari police station. Just like that. Okay.
Objection from there, man. Khanda kora objection from there. Objection of copy to the objection of copy to the wait for 1 minute.
21.
May I please, your lordship? My lord, this appeal is against the order dated 14/11/2022. In IA, that impugned judgment and order may be seen page 7, my lord.
The service is complete. In fact, on the earlier occasion, he served it on a female member, and now he had served it again to a related brother. That service report is there. Dada, Ratipaza
My lord, first thing, my lord, the present appellant is
That
behind
is-
the bar since November 2022.
This is the service.
And earlier also he was behind the bar almost 3 months.
It's there.
But today we are for bail before our lordship.
Yes, yes.
Kindly see the IA, that is 757/22. Page 9, the judgment starts. Kindly see, my lord, page 9 of the IA. The prosecution case in brief is that 23/3/2018, informant lost an Ezahar with the officer in charge of Borpeta police station alleging inter alia that on 7/3/2018 at around 12 o'clock noon, accused Miss Bahaul Alam called his minor daughter, aged about 9 years, to his house on the pretext of bringing something and taking advantage of non-availability of other persons, forcefully committed so on her, causing injury to her so, as a result of which bleeding so occurred, for which she had to be treated in government hospital for her injuries. It has been mentioned in the Ezahar that informant came to know about the real fact after 2 days of the incident, as the accused tried to suppress the incident and had threatened his daughter from disclosing the incident. It is also alleged in the Ezahar that the informant
But,
had.
Mahmood, this is not a case for grant of bail at any way.
No, my lord. My lord, I will satisfy your lordships.
Huh.
Kindly allow me some time.
No, definitely. We are not saying that, but the evidence which has come out in the
No,
trial.
no evidence at all, my lord. All evidences are contradictory. Star witnesses are differing from time to time. Let me satisfy your lordship.
Okay.
First thing, my lord, the FIR was lost after 16 days. After 16 days. Incident is said as on 23, incident occurred on 7/3/2018, and FIR was lost on 23/3/2018. So there is a gap of 16 days. Now, lordship, kindly come to page 12, man. Discussion of witnesses.
Yes.
Page 12, man. There are 7.
Yes.
The informant of the incident case is the father of the victim girl and was examined as PW1. In his evidence, PW1 deposed that the incident occurred about 1 year back, one day when he returned home at about 6 p.m. after his day's work. He found his daughter referred so as over 9 years lying on the bed with profuse bleeding from her so. Having seen her serious condition, she was immediately taken to so hospital for treatment, and there she was admitted and treated for about a week. During her treatment in the hospital, 5 stitches had to be given on her private part. PW1 further deposed that when he questioned his daughter about her injuries, she initially told, so this is very important, she initially told that she had sustained the injury by falling from guava tree. But she later disclosed the actual fact by stating that she had sustained bleeding injuries in her so-and-so because of so-and-so committed by the accused Khandakar Mesbahul Alam. She further told him that accused called her to his house on several occasions. Schedule 1 deposed that regarding this matter, he had filed the case. Schedule 1 also testified that during investigation, police recorded his statement. So in this way, he is saying this, my lord, he is implicating the present appellant. Now, Lordship kindly see 7.1, para 7.1. In his cross-examination, Schedule 1 stated that he knows a little bit of reading and writing. The Azhar was written by an advocate and he had put his signature therein. Schedule 1 stated that after treating his daughter in the hospital for a week, he filed the case about 10-12 days after her release from the hospital. He further stated that his daughter was released from hospital after 1 week of her admission in the hospital. So, my lord, first thing 10-12 days, then 7 days, originally 16 days later. During investigation, he had shown medical documents of treatment of his daughter to police, who then took some papers and few are with him. He further stated that he is living in a house constructed by accused in the Khash government land, which is under occupation of accused, the accused. Schedule 1 stated that accused asked him to vacate the land, but till today he has not vacated. So Lordship has seen here 3 points have already gone. First, 16 days later, the FIR was lost. Secondly, she said to her father that I fell down from the guava tree and sustained injuries. Thirdly, he says, I stay in the land of the present appellant accused, and he asked me to vacate the land, but I did not. So these are the very important questions Lordship would see. Then Lordship, when we go on, he also said that his daughter can climb in the small trees. He had not seen his daughter falling from a tree a year ago. He further stated it is wrong to suggest that accused did not commit sexual intercourse with his daughter. He denied the fact that accused directed him to vacate his land, but he did not vacate it, and being infuriated, he filed this false case against him. He also denied that his daughter suffered injuries on her so-and-so by falling from tree for which he treated her in the hospital. Schedule 2, Lordship, para 8. Schedule 2 is the mother of the victim girl, and she deposed that occurrence took place about 3 years ago. Schedule 2 deposed that one day she and her husband went out for their daily labor work. She came back home in the evening and found her 9-year-old daughter, victim, lying on the ground of their house, and there was profuse bleeding from her so-and-so. Her wearing cloth was sustained with blood. PW2 deposed that she then changed her dress, so-and-so, Lordship. Then page 15, man. Page 15, top. According to her, doctor had stitched her injuries to prevent bleeding. Her daughters remained admitted in the hospital for 3 days. Well, earlier 7 days told by her husband. Now she says 3 days. PW2 further testified that her daughter told her that she went to pay visit to the house of the accused, whom she says Nana, and there she sustained the injuries on her private part. PW2 also deposed that she do not want to speak about the incident. Then Lordship would say 8.1. In her cross-examination, PW2 has stated that they are residing on the land belonging to the accused. PW2 also stated that accused had asked them to vacate the land. She denied the fact that her daughter sustained injuries by falling. Then Lordship would say para 9, my lord. Para 9, PW3 is the victim and name being withheld. In her evidence, she deposed that the informant is her father and that she knows the accused. PW3 also deposed that her present age is 13.5 years. And she was born on 5/3/2009. According to her, the incident took place about 3 years ago at around 11 a.m. On the day of the incident, she was playing, Lordship, this is very important. she was playing with her younger sister and some of her friends. And while playing, she climbed a tree. And then she fell down from the tree and sustained injuries on her private parts, and her parents got her treated. The victim was declared as hostile by the prosecution as she resigned from her previous statement made before the IO. Now, Lordship would kindly consider this aspect. Now, she is under the custody of her parents since the day of so-called incident, and she clearly says before the Honorable Court, trial court, that she sustained the injuries after falling from the guava tree when she was playing with her friends. She also says she can climb, her father also told. So this is the quality. Now the victim girl was declared hostile by the prosecution. Then Lordship may kindly come to page 17. My lord, I am 74 years of old, my lord. Kindly see the nature of allegation, how they have only to, I asked them to vacate my land, and then the entire things were made up, my lord. Now Lordships kindly come to page 17, my lord.
Yes.
Page 17, 9.3. PW3 during her cross-examination by defense stated that when she was asked by her mother about the incident, she told her that she sustained injury by falling from a tree. Now, mother and daughter's statements are quite contradictory. May I read, my lord?
When I have free time, I read certain things just to amuse myself, because I have no other way to amuse myself. I can't roam about in the streets. I can't go anywhere. So this is what I do. You see, in Guinness Book of World Records, the oldest father recorded is 92 years. He fathered a son with a third wife at the age of 92. His name is in the Guinness Book of World Records. An Indian has a record of being the oldest father, but his name, I don't know why, did not enter into the world records. He fathers his first child when he was 94, and second child when he was 96. His name is Raghav. His name is 90. His age was 96 then. So when you said this about your age, it triggered something, and I just
like that.
Reading the net. This is the only source of information I have, and that is the information I am getting.
So his
Well,
argument goes.
Some more things are coming. Interesting things are ahead.
It's okay. Don't let it bother you.
My lord, now, my lord, actually, my lord, this is a clear cause of acquittal. Only emotionally, the judgment cannot be delivered, my lord. There should be a moral conviction. There will be legal conviction. That is my submission. Can listen now 9.3 after 4 lines. But later she disclosed the real facts. She further stated that her parents had a land dispute, Lordship, with the accused. PW 3 stated that PW 3 means this victim girl. Stated before recorded a statement in police station and read over the statement to her. After it was recorded, she denied the fact that she has given false evidence due to land dispute. She further stated that police seized her blood-stained clothes and that she had not seen those in the court today. So, when a trial is also questionable trial. This blood-stained, so-called blood-stained clothes, there may be blood. It is admitted. But whether that was due to misdeed by the accused or the falling down from the guava tree, that is a serious question, because she differs her statement from time to time, and she is the star witness, madam. Now, everybody is admitting that there is a land dispute. I allowed them to stay in my land. When I asked them to vacate, then this story was concocted and this old person has been implicated. Now, Lordship, kindly see page 18, my lord. Page 18.
Yes.
My Lordship has seen the father, mother, and victim girl. Now, this is the independent witness, purely for Anwar Hussain. Anwar Hussain, page 18, stated in his evidence that he knows the informant, accused, and also the victim of this case. The informant is his neighbor, and that victim girl is the daughter of the informant, who was aged about 8-9 years at the time of incident. PW4 deposed that incident took place in the year 2018. One day when he returned home from his office, the informant came to his home and told him that the accused used to call his minor daughter to his house on various pretexts. The witness was declared hostile as he recited from his previous statement made before the IO. So, my lord, here this independent witness Anwar Hussain
Yes.
Now, my lord, now kindly see page 18 bottom. This is a cross part, bottom of Anwar Hussain, PW4. He clearly said that, kindly see the bottom 2 lines. PW4 stated that accused is also from his own village and that he knows him personally. He denied that he had suppressed the actual fact and had deposed falsely to save accused. Now, this witness did not support the case. Then PW4 in his cross-examination by the defense stated that informant resided at Metuakusi village and his village is Shonkusi, and that both the villages are adjacent. The house of the informant is situated at a distance of ½ kilometer from his house. Para 11. PW5 Amjad Ali stated in his evidence that he knows the informant and the accused, but that he has no personal knowledge about the incident, Lordship. These 2 independent witnesses are not supporting the prosecution case. Now, PW6, Dr. Anima Bora. This is also very crucial witness matter. Dr. Anima Bora, the medical officer of the case, stated in her evidence that on 23/3/2018, while she was working as lady medical officer on duty at Department of Forensic Medicine, Fakhruddin Ali Ahmed Medical College and Hospital, Barpeta, she examined X, aged about 10 years, female, daughter of so-and-so village Metuakusi, on being produced by W.J. Homgard Jamila Khatun in connection with Barpeta PS Kasaba. So she was treated at gynecology ward on 7/3/2018 to 10/3/2018 for bleeding her so-and-so at Barpeta Hospital. History of the alleged sexual assault by Khandakar Mesbaul Ali, 65 years, on 6/3/2018 at around 2 p.m. Daytime, and history of treatment of the victim on 7/3/18 and 10/3/18 for bleeding per so-and-so physical examination, Lordship will see these are things. Now Lordship kindly see bodily injuries. Bodily injuries, no body injury detected. Lordship, an 8 or 9 years girl, no body injury is found. Then Lordship will see there are some clinical examinations. All things would show there is nothing at all. Now, opinion of the doctor, Lordship kindly see page 21.
Yes.
12.4. There is no recent sign of sexual intercourse, but there is all sign of sexual intercourse as already healed on left side of so and so. Now, Lordship, this is very important. No recent. If anything has happened with me, that is recent. Earlier, see, I am not blaming this small girl, but thing is this, that might be another person also. If doctor is the expert, he is saying that, but there is all sign of sexual intercourse. So that is not related with me. Presently, there is nothing. There is no injury on her body except already healed on left side of so and so. There is no X-ray report so and so. Then Lordship may kindly see 12.6. In her examination, PwC stated that the healed wound on left side of so and so well maybe caused 12-15 days prior to her examination on so and so. Such wound cannot be caused by falling over hard substance. Though the victim was admitted at gynecology ward, she did not examine her from 7/3/2018 to 10/3/2018. PW7 Inspector Rahul Deuri, the investigating officer of his case, in his evidence stated that on 23/3/2018 he was working as second officer at Borpeta PS. On that day, one lost an Azahar before OC Borpeta PS, which was accordingly registered as so and so case, POCSO Act, and the case was entrusted to him for investigation. Taking upon the investigation, he examined the informant and his wife and recorded their statement. The statement of the victim was also recorded, and she was thereafter sent immediately to FAM Hospital, Borpeta. And on the very same day, the victim was produced before the magistrate for recording her statement under section so and so. He then went to PO, prepared a rough sketch map of the PO, and also examined the other witnesses of the case. He also seized the birth certificate of the victim from the informant as per which the date of birth of victim is 5/3/2009. The original certificate was later handed over to the informant in Jimma. Now, Lordship, kindly see the last 3 lines. After completion of the investigation, he submitted charge sheet against the accused Mesbahul Alam under section 6 of POCSO Act. Now, page 23, my lord. He deposed that he had recorded the statement of witness Anwar Hussain, and the said witness in course of the investigation stated before him that 2 days ago he came to know from with so and so, taking advantage of the absence of his family members, Mesbahul Alam called his minor daughter as so and so to his house and thereafter raped her, as a result of which the victim girl sustained serious injury on her private parts, and there was bleeding so and so, so and so. Then Lordship may kindly see para 13.3. PW7 in his cross-examination stated that prior to his sending the victim girl for medical examination, the victim was taken to a doctor by the informant side on their own. He also stated that he had not ceased any wearing apparel of the victim. Lordship, here is very important. The girl said that wearing apparel was seized by police, but he says nothing was seized. Now, Lordship, if there is any blood stained clothes, and if that is not sent for serological examination, that is a defective investigation. So that benefit would go to the appellant or accused. Secondly, my lord, the difference between the evidence of 2 star witnesses, that is a clear case of acquittal, my lord. Now here are the star witnesses, guard, doctor, and IO. Their evidences are disputing from each other on material point, my lord. Then Lordship may kindly see page 24. She is DW, and What type of DW, my lord? Lordship is aware that DW is normally given taking risks upon the accused person. Lordship is aware about this provision of law. Even then, Lordship kindly see her statement. Page 24. DW1 is Shabnam Begum, and in her evidence stated that she knows the informant as his wife worked as a maid at their house. Girl's mother works as maid servant in his house, in her house. DW1 is deposed that she also knows the accused who resides in their village. According to her, the alleged incident took place in the year 2018, and that one day the informant's wife came to her and asked her for a sum of rupees 1,200, which she owed to her. She told her that she needs the money for the treatment of her child, as her child fell down from a tree and sustained injury on her so-and-so. DW1 further testified that after she gave the money, the informant's wife took her daughter for treatment, and after 3 days, informant's wife along with her daughter came to her house. Later, she came to know that informant had filed a case against the accused of committing bad act with the informant's daughter. The informant used to stay at the land of the accused, and as the accused asked the informant to vacate the land, the instant false case had been filed against the accused. DW1 also testified that the informant, however, vacated the land of the accused later on, after punishing me. So, Lordship, here, Lordship would kindly see that the statement of victim girl, her mother, father, and doctor, as well as IO, all are questionable, all are doubtful, suspicious. And the root cause is this, that, my lord, nowadays, there is a tendency of some persons to occupy others' land. My lord, I am from a well-to-do family, and I allowed them to stay in my land, constructed by me. But they committed something which was not liked by me. I asked them to vacate. Then entire story was concocted. FIR was filed after 16 days. That is a good ground, my lord. Now, in support of my case, my lord, I have brought some citation. I have also given the citations early in the morning. Now, Lordship, for granting me bail, because, my lord, I am more than 1 year I am in custody. Earlier 2.5 months, and there are since November 2022. Kindly see, my lord. 2014, 2 GLT, 252, para 9, 10, 11, and 15, particularly 15, Lordship. My lord, may I
Please
read
give
my-
the citation again.
My lord,
Which
this is
citation?
2014, 2 GLT 252. My lord, may kindly say para 11 first.
Para 11.
Yes, there are 11 and 15 and 16. 11, 15, and 16. May I read, ma'am?
Yes.
Para 11, the material facts adduced by the prosecution are very prominent, and there should not have been any divergent version in respect of a prominent fact that there is no inter se corroboration. Therefore, we are of the opinion that it is not safe to place reliance upon the evidence of the prosecution witnesses. The evidence of PW 1 to 5 shows that they are witnesses to the incident. More so in the context of delay in registering the FIR, there could be a possibility of concoction of the eyewitnesses. It is in the evidence of PW 7 that family of the deceased would be benefited, very important, if the accused is convicted and sent to jail, as the property of the accused will come to the family of the deceased. In the backdrop of such material, it cannot be said that the defense story of implicating the accused falsely is likely to be brushed aside. So here is a case where these things are available. If I can be sent to jail and they have succeeded in their plain matter. Then Lordship kindly see page 15, para 15. There are also some other observations, but para 15 Lordship may kindly see. Coming back to the facts of the case, as observed above, the evidence of the supposed eyewitnesses does not inspire confidence of this court to believe that they can be treated as eyewitnesses to the incident. So here is only one eyewitness, that is the victim girl. Now, victim girl is reciting from her statements every now and then. But she is one point everybody is saying that they are staying in my land. In the house constructed by me. Everybody is admitting this. And when I asked to vacate my house, then this story was confirmed. The doctor says there is nothing. Well, there is nothing, doctor says. What more is required? My lord, conviction should be beyond reasonable doubt. But I am not on that. For that, I shall have to go through deeper scrutiny of the matter. But for the time being, Lordship would say, lastly, Honorable High Court held, in view of the discrepancies in the conduct of the investigation and evidence adduced by the prosecution, we are of the opinion that the order of conviction is bad in law and same is set aside. Now, Lordship, IO's role is also not good because he did not send the serological examiner for his blood stain was not sent. Then Lordship may kindly see 2014 3 GLT 134 para 30, 31 and 32. Here is regarding hostile witness. Whether a hostile witness is totally hostile, what is their evidentiary value, the Honorable High Court has discussed. Para, what is this addition? 2014 3 GLT 134.
Yes.
Para 30, 31 and 32. Now Lordship kindly see 30. It is settled position of law that because the witness is declared hostile, his entire evidence cannot be excluded or rendered unworthy of consideration. Merely because the court gave permission to the prosecution to cross-examine its own witnesses, it does not affect his evidence. The evidence remains admissible in trial and hence there is no legal bar to base the conviction or acquittal upon the testimony of such witness. Merely on the ground that witness has been declared as hostile, his whole testimony cannot be excluded from consideration. In appropriate cases, the court can rely upon the part of the testimony of such witnesses if that part of the deposition is found to be credit-worthy. Yes, para 31. Admittedly, there is no eyewitness to the occurrence. The prosecution case is based on the circumstantial evidence. An accused can be convicted based on the circumstantial evidence, provided there are incriminating circumstances appearing against him in the evidence and chain of circumstances. This is very important. Chain of circumstances is complete, pointing to the guilt of the accused only and no one else. Here, my lord, chain of circumstances are not pointing to me. While Guwahati, she fell down, sustained injuries. Doctor says no injury at all. Some old affairs may be there. So, and there is also land dispute. So, all these are negating that the chain of circumstances is directly pointing out to the appellant accused, which is not at all here. Now, so far the one victim, only the sole eyewitness, she is differing from her statement every now and then. Every now and then. And for their so-called discrepancies, so-called inimical conduct, I am in jail, madam, 74 years. Kindly consider this aspect. Then, Lordship, I will come to next citation, my lord. That may kindly be seen, my lord. 2004, 9 SCC 193, para 9 and 10, my lord. Para 9 and 10, and 16 is regarding hostile witness. What is the value of the hostile witness? First, Lordship, kindly see para 9 and 10. There are 10 may be said, 9 is long matters, long discussions. There are 10, kindly see. 10. We also noticed from the evidence of PW 10. We also noticed from the evidence PW 10 and others that when they touched the body of the deceased, they found that the body was cold and frozen, maybe so used by the locals for the body having become stiff. Therefore, we think the trial court was justified in its finding that death had occurred much earlier. Thereafter, Lordship may kindly see later on. The FIR reaching the judicial magistrate more than 36 hours after the incident. My lord, 36 hours later, the FIR came to the court of London magistrate. Now, here is a gap of 16 days. They have got ample chance to concoct the story. They planned how I can be implicated. So they got chance. Magistrate more than 36 hours after the incident in question, though the court is situated in the same town. Lordship, no, it is not same town. It is though the court is situated in the same town, it is also applicable in our case. Metuakusi is a part of Borpata town, my lord. Metuakusi, just after crossing the river, there is Champa river, Champabuti. After crossing, that is Metuakusi. So that is a part of Borpata Municipal Board. So here in the same town, incident occurred. Hardly the police station from Metuakusi is 2 furlong, hardly 2 furlong, and delay of 16 days. And father says nearly 10-12 days she was in hospital. Mother says 2-3 days. And if there be 10 days even, why 16 days later FIR was filed? Then Lordship may kindly come to para 16, my lord. Regarding para 16, regarding hostile witness. Para 16. We are at pains to appreciate this reasoning of the High Court. This witness has not been treated hostile by the prosecution, and even then his evidence helps the defense. We think that benefit of such evidence should go to the accused and not to the prosecution. Therefore, the High Court ought not to have placed any credence on the evidence of such unreliable witness. So my only ratio of this case is this, my lord. If even a person is declared as hostile, but if that witnesses' statements are otherwise found something beneficial, that benefit will go to the accused, not to the prosecution. But here the contrary view is taken by the London trial court. So Lordship would kindly consider this. Then Lordship,
yellow highlighted. Highlighted portion, take that. Highlighted portion, take it.
Only 2-3 citation, my lord. I am reading only here, my lord. Only here, that is 2002 9 SCC 663. Here, I am reading only the editor's part. Para 2, my lord. Para 2 short para. The two convicted persons, namely Jai Prakash and Shanti Devi, preferred criminal appeal in the High Court of Punjab and Haryana against their conviction and sentence. The learned judge reappreciated the evidence and came to the conclusion that the two star prosecution witnesses, namely the father and the brother of the deceased, have made so many improvements in their testimony from stage to stage that it is difficult to place reliance on their testimony and ultimately acquitted them of the charges leveled against them. So, my lord, this was the view that which was upheld So my prayer is this, against that judgment of acquittal, they preferred appeal, but in the state filed appeal, but the appeal was dismissed. That is para 3. It is Supreme Court judgment 2002 9 663 para 2. That Lordship, then my next citations, Lordship may kindly see.
This is a copy of that 2002. It's not there.
Here also, my lord, direct conflict between medical evidence. My lord, this is very important.
No, this 2002, just
2003 10 SCC 700. My lord, para 8 and 9. Here the Honorable Supreme Court clearly says, held the direct conflict between medical evidence and oral evidence. Then the High Court erred in concluding that the medical evidence supported the oral evidence. So that is not here, it is on record, my lord. So it is the Supreme Court said that when there is conflict
which
between,
citation you are referring to?
my lord, 2003 10 SCC.
2003 10 SCC. Just a minute. Para?
Para, my lord, 8 and 9. The conflict between medical evidence and oral testimony. 8 and 9, if your lordship permits me, I may read. Para 8, my lord. Having perused the evidence of Petition 1 in its entirety, as also the medical evidence, we are not in a position to agree with the High Court in regard to the acceptability of the evidence of Petition 1. First of all, it should be noticed that in the above extracted portion of the judgment, the High Court has observed that evidence of Petition 1 is supported by medical evidence. But when we peruse the evidence of the doctor, PW 16, as also the injury memo and the postmortem report, we notice there is a direct conflict between the evidence of Petition 1 and medical evidence. So ultimately, my lord, the Honorable Supreme Court has acquitted the accused, that is para 10, my lord. Para 10. Para 10. From the above discussion of the evidence led by prosecution in the case in hand, we are satisfied that the High Court fell into the error in reversing the judgment of the trial court. Therefore, this appeal succeeds and the same is allowed. The judgment of the High Court is set aside. The conviction and sentence imposed on the appellant are set aside. The appellant shall be set at liberty forthwith if not required in any other case. So, Lordship has seen this case, these citations are very much appropriate and befitting in my case. Now, our another last citation for today for the IA, that is 2013 1 GLT 113 para 24, 26, 30 and 31. Let me see certainly the relevant point only, my lord. That is 2013 1 GLT 113 para 24. Lordship may kindly see para 24. Para 24. It is important to note that neither the spear nor the spade, which had been seized by police, was sent for serological test, and there is no evidence to show that these were weapons of offense. This apart, though Petition 4 is a witness to the seizure, he has clearly stated that the police had beaten the accused persons and that he was merely asked to sign on the said seizure list. So, was sent. That is, it is said that which had spare, not the spade which had been seized by the police was sent. So, the blood stained clothes which have been seized by police, which has been also admitted by the victim, that is witness number 2, PW3, my lord. Then that was not sent for serological examination. So this was a serious lacuna on the part of the prosecution, and ultimately the Honorable High Court has come out heavily that when there is such and such things, the acquittal of the accused was given. That is, may kindly see para 33, my lord. Para 33. Because of what have been discussed and pointed out above, this appeal succeeds. The imperial judgment and order dated so and so aforementioned shall accordingly stand set aside. The accused appellant are hereby held not guilty of the offence charged with, and they are acquitted on the same under benefit of doubt. So, my lord, at least, my lord, I will get the benefit of doubt in the long run. But for the time being, my lord, my learned friend may say so many things, minor guard. So what? Conviction should not be moral, it should be legal. My Lord Justice, I remember one judgment of my Lord Justice Vishwas. He said clearly that dignity of the woman must be preserved, but without emotion. There must be legal evidence. So the case is of POCSO, that is not the ground. Whether you have proved the case as per law or not, and what circumstances are saying, my lord. So, my lord, in my humble opinion, my lord, the case DW has clearly stated that she came to
taken a notice that
all these things.
here, Ms.
So, my lord,
Jahan-
at least bail may be granted, and lordship, there is another judgment. I remember today, unfortunately, I have not brought. Bail should be granted liberally, because the things when the accused, my item number 17, my junior friend has given one citation 2030. Om Prakash Chaudhary, that judgment is there. Bail should be granted liberally pending appeal. That judgment is there. There are several judgments on this point, because the days which the person is in custody will not return back after acquittal. So, my lord, may kindly grant me bail.
In these cases of 376 of POCSO, the statement of the prosecutor says
as the applicant herein has been convicted for committing offence punishable under section 302 IPC and sentenced for life imprisonment, the issuance of notice to the respondent to in this application under section 5 of the Limitation Act is dispensed with. Next paragraph. By this application under section 5 of the Limitation Act, the applicant has paid for condoning the delay of 304 days beyond the period of limitation in filing the connected appeal against the judgment and sentence dated 31/8/2022 passed by the learned Sessions Judge Baksa, Mushalpur in Sessions case number 15 of 2019. Next paragraph. The Learned Legal Aid Council has submitted that the Learned Legal Aid Council was entrusted this matter to by a communication dated 30/5/2023 issued by the Guwahati High Court Legal Services Committee upon receipt of request for legal assistance to the applicant And thereafter some time was consumed to obtain instructions and to file an appeal, which was done on 13/9/2023. And by then, the delay of 304 days had occurred. Next one. Although the learned additional BP has opposed the prayer for oppose this application, but considering the explanation tender and taking into consideration that the the connected appeal was filed only pursuant to request made by the Guwahati High Court Legal Services Committee. Court is inclined to accept the explanation tender as good and sufficient cause, which had prevented the applicant to file the connected appeal on time. So accordingly, the aforesaid delay in filing the connected appeal stands condoned. The registry shall now register the connected appeal and list the same in the admission column.
Please. As for the direction of last one. Please. We have already filed the asset and liability. And we have paid the cost already put on our.
Please repeat again. We did not get it. Please repeat again.
Lordship, we have filed the asset and liability affidavit on yesterday, but I think it was not paid.
No, please repeat.